Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police versus Latino.
Literally not true.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I'm also in love with this camera shop. Black Magic Design, please sponsor me. I need more of these. This is... Does that just not look good? Oh my goodness. I love it. I love it. I love it. I've got to tweak it a little bit. Hopefully today I'll get the other cable and we'll be able to adjust it a little more live. But all right, welcome. Come on in. Take your seat. I see most of you are seated already. That's wonderful. I have to recognize a couple people who were a little early. Britta Aller, 18 months. Congratulations, Britta. Another fabulous month with this fantastic family of true crime addicts. Little Man in the Corner does a fantastic job, and the fabulous mods. Kiki's Garden also kicked it off with a free membership for someone. Thanks for the gifted membership. But we can't forget Cheryl C. Cheryl was first in chat this morning. Congratulations, Cheryl. That's awesome. We're super excited for you. We're so excited, as a matter of fact, that we are going to give you something, in a way. We're going to give you a punishment. Yes, we're going to punish you for a good deed. And we're going to send it to you to internet ownership for the rest of the day, or at least until we go live again. So maybe we'll take a lunch break for your benefit, and then we'll be good. Yes, I love this camera. This camera, that one, cost almost identical what the Sony a6600 cost me. I think it's worth every penny. Oh, it's beautiful. It's so beautiful. It's dark. It's dark right now. I've got the lights down low so that I don't get a headache. But it's all good. Let's see. Oh, I'm wearing black. I need to change. What color should we have in the background? I think we need blue. Hey, Siri, change my lights blue.
Bring the jury.
It's thinking about it. There we go. We've got a little bit of blue over there. That's blue and black. It goes well together. All right. Where are we? That I don't need. Love these breath strips. I know a lot of people think they're disgusting, but oh man, I like them. All right. I don't need this keyboard right now. I think I'm going to need this, so we'll keep this over here. And welcome. You want green? I'm not sure how. We'll try green. Hey Siri, change my lights green.
I saw a chicken fight.
Saw a chicken fighting. There we go. Does that work? Not sure. Oh, man. Good morning, everyone. Good morning. Debbie has a question about game consoles. I read your email the other day, Debbie, and it's about USB extenders.
I'll install it.
Was it PlayStation or something? I don't know. But the controller's not working right. So if one of you happens to be a game console repair technician, that would be a good time to step up and help Debbie out. Congratulations. Oh, look at this.
Is that correct?
Debbie. RA, I sent you something, but it has been stuck at the post office in Wilmington, North Carolina for days. It was one of my best pieces, too. In Wilmington, huh? Why would it get stuck in Wilmington? Interesting. And Debbie, I'm
The
super
zombie
excited to see it.
apocalypse may be upon us.
Debbie does great work. If you don't know,
Happens
the Creative
someone
Bee
with
over on
more
Etsy,
experience.
handmade with love. Does some great work. All right, congratulations, Debbie, on 20 months. I can't wait for the post office to get it together and get it to me so we can show it off to everyone. All right, we have today what we're going to focus on this morning is the Bryan Kohberger hearing, because we have finally the agenda was released today. We're going to go over that of what's going to happen. We have to do birthday things as well. So
Shame on you, sir.
Yes, shame on me. I missed that. Don't miss the birthday song. Okay, here we go. Birthdays. Refocus. Get Bryan Kohberger out of your mind for just a minute. The stabby trial is going to be, we'll have plenty of time to talk about in a minute. But first, we need to focus on the people who have birthdays today, and that is True Crime, Out and About with Diane, Sprout, who is a dog, not a cat. Rich, that timing was perfect. Rich G, all celebrating birthdays. So True Crime, Out and About with Diane, Sprout, and Rich G. So this is how it works. I'm going to sing. You're going to sing with me. I will play the music. We all sing together. Please, if you're able, meaning that if you're able to stand, or you're in a location where you can stand, I guess both of those have to be true, please stand up. Take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. That's great. Sounds great. Everyone's ready. Dancers at the ready. We're going to sing to these four wonderful people, and well, three wonderful people and one wonderful dog. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, True Crime, Out and About with Diane, Sprout, Woof Woof, and Rich G. Happy birthday to you. I even fit the woof woof in there, which is dog talk for happy birthday. True Crime, Out and About with Diane, Sprout, who's a good boy, and Rich G. All celebrating the birthday. I realize there are a million places you could be and a million people you could be with, but you've chosen to be here with us. The privilege and pleasure and honor is all ours, but hopefully we can return, just a portion of that. Oh, we've got one more portion of that. Right, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Cherish, and heavenly birthday to Patty. Happy birthday to you. Sorry, we got some late arrivals there. Just because we sang to you late and separate does not mean you were any less special than everyone else. Help yourself to free pancakes at Village Inn, IHOP, Denny's, Waffle House, McDonald's, Andy's Grill. I can't think of any others. Every day, that's all I can. Who else makes pancakes? My wife did. If you were here, you would have got a free stack as well, but don't be here. There are better places to be in this morning celebrating your birthday. Thank you very much. Hopefully we can make your day a little more specialer. It's wonderful. Dog Mom, RA is the goat. The goat. You said goat. The goats are hiding. You can't see them. I need to set them up on my laptop. So there you go. Now you can see the goats. They're crystal clear. It's beautiful. Oh, that's the drum solo, meaning the drum tease, meaning the drum solo is coming up. Everyone, please grab your air drumsticks. We're going to pound the toms and then the crash. Here we go. So it's like that. So there you go. Yeah, that's it right there. Eileen, you nailed it. All right, happy birthday. With that said, and with that set up and established and permanently recorded in history, we can now go on to talk a little bit about first of all some people who met some thresholds, like Tori the Seed Lady. Happy Friday Eve, or as we like to call it, Podcast Thursday. Yes, very much. Thank you very much. We've got Debbie for 20 months, one of our OGs, an amazing supporter of the channel. Dog Mom, member for 13 months, says Ari is the GOAT. Thank you very much, Dog Mom. With that said, let me just read to you just a wee bit. I'm not sure where can I put that. I think I can send this somewhere. If I download it and save it to Big Dill, there we go. was doing wrong. Okay. I think I figured it out. I'm going to set up StreamYard over here to stream to Top Mark Media, but I'm going to go something. Yeah. Okay. I'm good. I've got it figured out now. Let's save order of proceedings there so I can open up on the other computer. I've reworked my network a little bit, so not everything is connected to each other. Hoping that would fix some issues. Order proceedings. There we go. And this will come over to camera 8, which is currently hiding. Nope. Camera 4, 3. I think it's 3. It's camera 3. I don't know why, but I also changed the numbers of all my cameras, so everything's messed up. All right, there we go. Zoom in a bit. I lied. I do need this computer or this keyboard. There we go. And minus. Okay. Now we can pull up what we're talking about today, which is the Bryan Kohberger hearing, and we can do that on camera 3. All right. This is what we're going to go over today because this is what's happening. If you look right over here, we're waiting for the live feed from the courthouse up there in Boise, Idaho. So we've got that ready to go, and we're waiting. But this is what's going to happen. This was just filed yesterday in court, and it says, let's see, State of Idaho, the plaintiff versus Bryan Kohberger, order of proceedings for November 7th hearing. And guess what? Today is November 7th. It goes like this. The motion set for hearing on November 7th will be heard in the following order and within approximate time limitations indicated. Beginning at 8:30. This is Idaho time, so it starts in, let's see. It starts at 11 our time, which means we have an hour and 40 minutes. Beginning at 8:30, the motion regarding street clothing at public hearings. So it looks like these are being reheard because he's been wearing street clothing at public hearings up to this point. So they expect 20 minutes on that one. But that one is closed. This is key. Closed means we don't get to see it. Then, beginning at 9, sorry, a sneeze is coming on. If the good judge would have said bless you twice to me. I chose poorly, by the way. I turned to sneeze, and right as I'm sneezing, I realized I'm sneezing at my fan. Which, yeah, doesn't work. Okay, so that one's going to be closed. Then, beginning at 9 a.m., state's objection to testimony of Barbara Wolf. So we might also hear from Dr. Wolf if necessary. 20 minutes or to be determined. This is the state's objection to one of the defense expert witnesses, I believe. Oh, no, I missed something for Julie. Hang on. Sloth Life, thanks for gifting a membership. Appreciate that. Abby J, my husband and I found out we're expecting twins. I'm terrified of 2 newborns at once. Oh my goodness. Abby, I'm doubly excited for you. I'm just I'm beside myself. That is like redundantly wonderful. I don't know how. What other sort of puns can you use to celebrate twins? I will say I believe your life is going to change for the better in ways you never thought it would. That sounds so exciting. You're going to be a great mom of twins. And please keep us informed. Start a channel, because Abby, how you feel right now, there are many other people who have been in your exact situation saying, oh crap, now what? I could do 1. How do I do 2? Document it, share it, and you'll find a community that not only is there to support you, but just leans on you for advice and support as you learn and go through that experience. Is crazy. That's really cool. That's really cool. I always wanted to be a twin growing up. I guess my desire was pretty much thwarted even from the first moment that I had the desire, because I was already an only a single child at the time. But I'll be watching from the hospital. Can we name them, Abby? What is it? What would it take to get us naming rights, or even just one of them? Can we like split it and say you name one, I name one, and then we like seal it in an envelope, and then you open it and it's like surprise, and it might be the same name, but we go with it anyway. What would it? No, I don't want to interfere in that way, but that is exciting. I'm captivating. Got caught in the YSL saga. LOL, it's about over. I'm back now. Oh my goodness, it's unraveling, and in a way that I never thought it would. With a plea deal, I was thinking mistrial. OG Sean White, Abby, good luck. I'm a twin, and my mom had 2 sets. I'm praying for you. Abby, this is what I'm talking about. People who know are there to support you. OG, thank you very much, Sean. I appreciate that. Let's see. I missed something from Julie. Where I'm not seeing it. Julie had requested some thoughts and prayers for something, and I didn't see it. I apologize. Did you guys see it? Please tell me you saw it. I've gone back as far as I can. I cannot see it. Can we do a poll for it? A poll for the names? I'm good with that. There might be some other decision makers, so to speak, that aren't on board, but I think that's a great idea. Abby, you down with us naming your twins using the standard poll method? We think it's 2 girls right now based on early blood tests. Start thinking on names. All right, there we go. I think Abby can safely say she will consider any option we propose. And maybe we'll give it the consideration that it deserves. I have twin girl granddaughters. They're amazing. Oh, she's not doing well. Needs kind thoughts. Julie, here we go. Thank you, Adam, for finding this. New member doing really poorly. Could use some kind words and wishes today, friends. If you can spare any hands, yellow, heart, and red. Yes, please. Julie, I'm sorry you're not doing well. First of all, thanks for sharing. Sometimes it's hard even to come out and say, hey, guys, I need a hand here today. Can you guys help me out? I appreciate you letting us know. There are a lot of people who will definitely have you in their thoughts and prayers today, as well as you're seeing some great well wishes in chat as well. So hope for the best for you. Hope things turn up. That's a little garden joke. Turn up, All right, we have, going back to the agenda here, the objection to the state's testimony with Dr. Wolf, about 20 minutes. That's going to be the first thing we hear if this first part's closed. Then there comes the big one, motion regarding method of execution. And we're going to look into this one more time. I'm going to just summarize it. We're not going to read all 14, 15, 16 pages again today, but we'll just summarize what this is about, because I think they are going to make a little bit of an oral argument in addition to the filing, but it's going to be pretty quick, because 20 minutes is not a long time to decide whether or not there's the death penalty on a case. So either the judge is looking at this and saying there's nothing there, we don't need much time, or I don't know. We'll see how that one goes. That's the big decision maker. It's not nearly as important as whether or not he can wear street clothes at public hearings prior to trial, right? State objection to testimony of Professor Cover. So this is another witness for Bryan Kohberger. Possible testimony there. Then we have a motion regarding arbitrariness. Yeah, you knew we were going to go here, huh? Hey Siri, define arbitrariness.
Arbitrariness means the quality of being based on random choice or personal whim, rather than any reason or system. Do you want to hear the remaining one?
Oh, yes.
It means a lack of restraint in the use of authority, Autocracy.
Lack of restraint in the use of authority. So I believe that this complaint is coming from the defense. That motion, well, we can look into that a little bit, but that's going to be an interesting one. Then after that, it's 20 minutes. Then we have 40 minutes on motion to strike statutory aggravators. This is utter disregard, future dangerousness, and multiple murders. They want to strike this from the case. This is one other way of trying to eliminate the death penalty as a result. 40 minutes on that one, so that's going to be interesting. The little sub note here: these limitations are per motion, not per side. In the event more time is needed and the motions cannot all be heard in one day, the court will continue the hearing on, guess what, Friday. Okay, so there's that. Then we go on to the notice of proof of non-statutory aggravators. Notice and proof of non-statutory. 20 minutes. 30 minutes on the motion to strike contemporary standards of decency. What? We're getting rid of decency? No, I don't know exactly what this means. There's a motion. We can go back and look at all of these to see what they are. Then we have the motion to strike regarding speedy trial, lack of grand jury, and international law. That's going to be fun. Yes, we're bringing in international law. As a citizen of the world, Bryan Kohberger objects.
Have them send someone with more experience.
Sophia Starlin, orange looks good on you. It definitely does. Congratulations. You made it all the way to the year mark. You deserved that orange courthouse. Thank you for your support. So that's going to be a fun. Lack of grand jury. These are, if what we've seen before from Bryan Kohberger, they go back into like the 1800s in case law and try to say, hey, you did it wrong because of this case back in, 1790. It's just, it's a long time ago. And we might see some really epic case law like that with some strange language. Motion to trifurcate proceedings and apply evidentiary rules. Motion to apply evidentiary rules. I think this means more than what it looks like on its surface. We did read this trifurcate proceedings motion, and that's going to be good. But anyways, Judge Hippler has said this is the way it's going to go down. It's going to start on the 7th, and it's going to go possibly to the 8th. But we will be here for the long haul on this one. Lawful international law. It's just short of SOVSIT. Why do I have this pulled up on my computer? I don't know. That one's not mine. All right. A possible 2-day hearing. This is a big one. I would say this is one of the biggest issues that's been decided. Specifically, I'm going to say the method of execution, because this literally could take the death penalty off the table or solidify the fact that it's on. Let's see, the little testimony things, the street clothing, that's interesting. I think it's going to be granted. I realize, Ada County is different than Latah County. Latah County let him come in a suit, no cuffs, and now going to Ada County, they're like, oh, we do things differently here, so we're readdressing this. But method of execution is big. I'm not sure about the testimony, how key these individuals are. I'm pretty sure the state is going to say they're terrible. We don't want these witnesses. They're either not qualified or whatever. Defense is going to say our entire case hinges on this witness for each of them. Without this witness, we are not able to present our defense, and it seriously hampers us. So they're going to come out with some strong language saying we need this, and the state's going to be like, it's baloney. Let's see, motion regarding arbitrariness. That just sounds fun. We'll look into that one a little bit here. So let me go back to the listing. Let's see, which one do we want to see? Strike contemporary standards of decency. Where's that? Okay, we've got motion to strike international law. Where's the motion to strike multiple victims? Oh, he already did that, allegedly. He struck multiple victims. Oh, I think it means something else. Here it is. Reply and objection to contemporary standards of decency. I'm looking for the original one. Objection, standards of decency. Found it. This was filed on the 9th, so about a month ago. Let's see. Let me put this up. Where do I want that? Let's have this in the background. Is that all right? So we'll watch court in case anything happens. And now, let's do a super source. I want you guys to be able to read this along with me, but I'm missing one computer connection, so I have to transfer it over. I'll save that there. Objection, standards of decency. Let's make this one big. All right, continuous view. I wonder, how would I set that as default? All right, this is electronically filed. Looks like it comes in from the state of Idaho, by and through Latah County Prosecuting Attorney. Hereby objects to the defendant's motion to strike state's notice of intent. Oh, that's the... Okay, so let's look at the full title, because they've abbreviated it. That's where our confusion lies. State's objection to defendant's motion to strike state's notice of intent to seek death penalty on grounds of contemporary standards of decency. So this is another way the defense is asking to get rid of the death penalty because standards of decency say we shouldn't have it anymore. Comes now the state of Idaho, by and through the Latah County Prosecuting Attorney, and hereby objects to the defendant's motion to strike state's notice of intent to seek death penalty on grounds of contemporary standards of decency for the following reasons. The court should deny the defendant's motion, and first we got the analysis. The crux of the defense argument is that there has been a major shift in public opinion regarding the morality, decency, and humanity of the death penalty. We just don't think it's a good idea as a society anymore. A defendant suggests this shift has taken place among the states, internationally, and among religious and professional organizations because of this shift in public opinion and the alleged downward trend of the application of the death penalty. Defendant argues that the punishment now violates modern standards of decency, ultimately deeming the death penalty cruel and unusual punishment in violation of the 8th and 14th Amendments of the United States Constitution and Article 1, Section 6 and 13 of the Idaho Constitution. The 8th Amendment states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The 8th Amendment is applicable to the states through the Fourth Amendment Due Process Clause. Article 1, Section 6 of the Idaho Constitution also prohibits the imposition of cruel and unusual punishments. Capital punishment is not prohibited under the United States Constitution, and the states may enact laws specifying the sanction. That sanction. When considering whether a punishment violates the 8th Amendment, the court first considers objective indicia. Is it indicia? Indicia. I think it's indicia of society's standards. That means indicators, right? Of society standards as expressed in legislative enactments and state practice to determine whether it's a national consensus among the sentencing practice at issue. That's case law from State via Abdullah, and quoting Roper v. Simmons. So it's embedded case law. Next, guided by the standards elaborated by controlling precedents and by the court's own understanding and interpretation of the 8th Amendment test, history, meaning, and purpose, the court must determine in the exercise of its own independent judgment whether the punishment in question violates the Constitution. In State v. Abdullah, Idaho Supreme Court held that Idaho's death penalty scheme does not violate the 8th Amendment of the United States Constitution. The defendant argued that our evolving standards of decency, which mark our progress as a maturing society, no longer support the death penalty as an applicable sentencing option. He cited the increasing number of states that have abolished the death penalty or issued moratoriums on scheduled executions, as well as public opinion polls that tend to denounce the death penalty as a sentencing option. The court rejected this claim. While the defendant may have identified a shift in support for imposition of the death penalty, this shift does not provide objective indicia of society's standards, such as legislative enactments or legislative action, to allow this court to determine that there is a national consensus against the death penalty as a sentence for first-degree murder. They're saying it doesn't matter that the The USA Today public opinion poll on death penalty shows that the majority of U.S. citizens don't like it. That does not. That is not what the public opinion, the society standards are measured on. Instead, the law says you have to measure this based on legislative enactments or executive actions that have been taken. It's not just we polled 12 people at a bus stop. Bad example, I know. Defendant's argument here is no different than the argument the court rejected in Abdullah. A majority of states, the military, the federal government continue to allow the death penalty as a sentencing option. As the court noted in Abdullah, it's difficult to regard a practice as objectively intolerable when it is in fact widely tolerated. It's hard to say it's intolerable when it's actually quite tolerable. The conclusion from the state is that the court should deny the defendant's motion because this is an issue that has already been ruled upon by the Idaho Supreme Court. This case law is strong in this argument. Defendant is asking this court to ignore Idaho precedent as well as precedent set by the Supreme Court of the United States. This court should deny defendant's motion. So here they're saying it's obvious. It's obvious, you guys. It's pretty simple. We've already fought this fight, and the state won. We're going to win again. Okay, so that was the standards of decency, but that was from the state side. We have to go back just a little bit. Objection standards of decency. I think they probably summed up the other one well enough. Okay, let's go back to the agenda and see what else is coming up today we need to read in. Been here since Brooks, says Renee. Mostly lurking. Can you fix the video blurriness? Can I fix it? Is that blurry? Like, I can see the individual hairs on the goat's chin here. You might want to go down to the bottom right-hand corner of your screen. Click on the little gear button. And I'm talking about the YouTube window. Click the gear button and then check the resolution and raise it to as high as your internet speed will allow you to raise it without it being choppy. Or is it blurry on my face? Or are you talking about this? Is that better? It was. I think it was the mic. It was focused on my microphone, so we fixed that. Mission accomplished. All right. Next item on the proceedings that we want to look into. Method of execution we talked about already. Let's look at the objections to. Let's see. First one was Wolf. Objection to testimony from Wolf. Oh my goodness. This is another attempt to stop the death penalty. I kid you not. Hang on. Let me pull this over and where are we at? Right there. Okay, look at this. This is Wolf, the objection to testimony from Wolf. From the state of Idaho, by and through Latah County prosecuting attorney, hereby objects to the proposed testimony of Dr. Barbara C. Wolf in support of defendant's method of execution claim. Elvin Summer Moon, sorry, that was not 11. Elvin Summer Moon, welcome to the gallery. Thank you very much. 4 months. Appreciate your support. This is all happening today. Yes, it's a huge hearing, and we're here for it. We are here for it. We're going to follow this. So here they've got Dr. Barbara Wolf, okay, is going to testify in support of the defendant's method of execution claim, which they're saying that the death penalty. This is the motion they're mentioned. Motion to strike state's notice of intent to seek death penalty on grounds of vagueness and balancing aggravators and mitigators. So this is another angle at attacking the same death penalty. They are throwing literally everything at the wall to see if it will stick. They've got the request to say it's just not, it's not right. Don't have the aggravators. Don't impanel the jury to make them a death penalty jury. Don't allow the them to consider the fact that there are multiple murders involved. Divide the case up into 3 different parts so that they have to get the highest level in each of the cases in order to reach the death penalty result, instead of just having one case where the jury can come back and say, yes, death penalty. They're going every possible way to keep him from dying if he's convicted. I mean, from being killed, executed if he's convicted. As the state explained in its response, the defendant's method of execution claim is not ripe for judicial determination, which means Dr. Wolf's testimony does not satisfy Rule 702 of the Idaho Rules of Evidence, because it will not help the trier of fact to understand the evidence or to determine a fact in issue, because we might even not hear from Dr. Wolf. Wow. Okay, so that's going to be a juicy one. But, oops, did I just close the wrong one? I think I did. Where are we at? Got the order of proceedings right here. Okay. So we have the street close issue, then a death penalty one, then a death penalty one, and now we've got testimony of Professor Cover. Let's see if he's also about the death penalty. Eliza P. Cover. It's a short one. I'm not going to move it over here. This is the arbitrariness. It's addressing arbitrariness. Unbalanced equation. Welcome to the gallery. We're going to have a crazy and incredible day here with Bryan Kohberger hearing, which might go 2 days, depending on how lengthy this is. So we've got, I'll read this now. It comes out of the state of Idaho by and through Latah County prosecuting attorney. So the state is filing this objection to testimony from Eliza P. Cover, who's a professor. Hereby objects to the proposed testimony of Professor Cover in support of defendant's motion to strike state's notice pursuant to Idaho Code on grounds of arbitrariness. Professor Cover's testimony would not be helpful to this court. It is now well established in Idaho that testimony containing conclusions of law by an expert witness is generally inadmissible. As the Idaho Supreme Court has explained, when an expert witness offers a legal conclusion, it invades the province of the court to determine the applicable law. Defendant, so yeah, that is objectionable right there. Defendant submitted as Professor Cover's expert report a law review article titled "Narrowing Death Eligibility in Idaho." So guess what? Another way to try to whittle away at the state's ability to use the death penalty in this case. The article sets out the professor's view of the Supreme Court precedent on capital punishment and ultimately concludes that Idaho's high rate of death eligibility shows the capital scheme is failing to genuinely narrow the class of persons eligible for the death penalty and therefore violates the Eighth Amendment. Such legal analysis and argument is adequately performed by defendant's counsel, and admitting it through the professor's cover testimony would invade the province of the court to determine the applicable law. The professor does not have sufficient foundation to testify in a court of law as to the results of her empirical study. The proponent of the expert testimony must lay foundation for it. This means courts must review both the expert's qualifications and the records relied upon by the expert to determine whether the expert can establish the necessary foundation. Professor Cover did not have access to sufficient information to determine whether each of the defendants mentioned in her article were legally eligible for the death penalty. Neither Professor Cover nor the defendant provided this court with sufficient information such as it would fulfill its obligation to review the records relied upon by the expert to determine whether the expert can establish the necessary foundation. Defendant has failed to lay a proper foundation for Professor Cover, and this court should preclude her testimony. This is funny because you have here quite clearly the defense throwing everything they can against the wall. Death penalty. 2 is death penalty. 3, death penalty. 4, death penalty. 5, death penalty. 6, motion to strike aggravated statutory aggravators. That's how you reach the death penalty. 7, motion notice of proof of non-statutory aggravators, also tied to the death penalty. Motion to strike contemporary standards of decency. It's about the death penalty. 9, motion to strike speedy trial, lack of grand grand jury and international law. This one we'll look into. It might also be about the death penalty. And last, motion to trifurcate proceedings, dividing the case up, is to lessen the chances that the jury could reach the final conclusion of reaching the death penalty. That's why these are all wrapped into one hearing. And as they're trying to strike everything, throw everything at the wall and hope that one of them, just one of them lands, right? Because if you look at this, with if they get on this motion, if motion number 3, if that's the judge, it resonates with the judge and says you're right, granted, death penalty is out right there. It's over. The state cannot file for it. They cannot. It's not going to happen. But this is aiming for the moon. Okay, that's their moon shot. Kimar, welcome. Happy 17 months from the middle of the ocean. They had to reroute us from Grand Turks, so going to Nassau, Bahamas tomorrow. Miss you all. Careful in the Bahamas. We heard about what happens down there. Be careful. Or was that Jamaica? I can't remember. Whichever island you go to is important. There's different islands. Okay. Enjoy your cruise. I'm glad you can check in. Thank you very much. Let's see. Seeing that his attorneys are fighting so hard to keep the death penalty off the table, I don't know how confident they are in his innocence. If they were, they wouldn't have to worry about it. I think they're doing a thorough job. And I think they will say that they wholeheartedly believe in his innocence and emphatically do so. Let's see. If they strike the death penalty and take it off the table, can Bryan then accept a plea deal if they happen to want to offer one? I think at any point the state could offer a plea deal. I don't know if they're going to. I don't know. Generally, the state offers a plea deal for a couple reasons. It can be difficult to prove all the elements of a charge, and it might be incentive to them to accept a plea at a lower charge if they feel they can't get secure conviction at trial. Anyway, we've got a ton of stuff that the defense is throwing at the wall to the judge. The method of execution obviously is like this is like winning the lottery in all motions in a death penalty case. You're getting death penalty thrown out. It's no longer a death penalty. The objection to the testimony, these two, number 2 and number 4, this is the court hearing the state side saying, hey, some of the people they want to bring in and just tell you about all this death penalty stuff shouldn't even be brought in. Legally, that one can't testify because they're going to make a legal conclusion. So Dr. Wolf is out, and Professor Cover can't be brought in because they can't establish foundation to legitimize her testimony. So they're going to try to strike those two who would be adding to this argument before the court to get rid of the death penalty. The motion regarding arbitrariness, that also addresses the death penalty. Motion to strike statutory aggravators. When you have there are some charges that can only reach a certain conclusion or a certain penalty, like life without parole, automatic life without parole is a minimum, if there was an aggravating factor. It depends on the state law. In this case, with death penalty, I believe there needs to be aggravators to reach the death penalty eligibility. So if they can strike the aggravators, then you never get to the point where the jury's, impaneled to consider the death penalty. So they want to get rid of HAC. What is HAC? Let me go back and look on this one. HAC aggravator is heinous, atrocious, and cruel. They want to get rid of heinous, atrocious, and cruel, utter disregard, future dangerousness, which is the threat he would pose to either the public or other inmates in the future, as well as the multiple murders, which, well, if you don't want that one, there's an easy fix, but it happens before you're arrested and before the crime's committed. If they keep the death penalty, will it be two-part like we have in Florida? We're probably going to hear that as well. And Debbie, this is a good question because we've got this other motion down here at the very end, which is the last. This is the order of preference they'd like to win these on, right? The motion to trifurcate the proceedings, that's literally dividing up the court into 3 parts. I believe it would be a guilt phase as far as the base charge without aggravators. Then a proceedings based on the aggravators alone, and finally a sentencing proceeding. that yeah. Basically, you'd have to hit the highest level of finding on each one to make the death penalty eligible, is my understanding of what they want. Where did we read the international law one? Speedy trial. Let's find international law. See what they're about here. Let's see. I think we have approximately 1 hour before the court live feed starts, and it will promptly go into closed session. So we might not even get the open or the intro. Give me just a minute to set some stuff up here. I've got to do a StreamYard for Top Mark. All right, we're getting there. It's loading. Let me put this over here. Okay. Sorry, guys. I should have some music on in the background or something. Someone with more experience would have given you some. Where's our other? We haven't played this song in forever. If I can find it. Here it is. All right. Hold tight for just a second while we get this set up. Of course, I just deleted everything I just did. All right, it's slowly building it. Mel Stiller, thanks for the kind words. Welcome. I'm excited to have a Bryan Kohberger day. This is a case we've been looking forward to for a long time. Red Pen, that's me singing. Y'all like that? Red Pen, that's why I'm playing it. You did a great job on this one. John says, all right, all the death penalty arguments are just moral issue and not for regional court to decide on state and national policy. As you say, this about just throwing everything at the wall. I believe we're going to have a clean sweep loss for the defense today. Possibly even on which witnesses can come in and testify. This song is called Cloud Chaser. Cloud Chaser was the name of that song. And it came with my Rodecaster Pro. when I bought this, it was preloaded on it, I think. Like, I don't know if it was sold before and somebody loaded it, but I've had it. I think it's also in the YouTube library, the free library if you're a content creator in the program. Okay. Okay, we've got Bryan Kohberger. We're going to schedule it for starts when in an hour. I'm going to use the same thumbnail from our channel because I know the guy that made it, and he's good with that. It was me. Okay. You think the death penalty would be taken off the table? Is that what I heard? Minnesota nice. I say no. I say the opposite of that. Here's what we have with. Let's go back to what are you guys seeing? You're seeing that. Let's go here. With all these motions that we have on the table here, for the agenda. First of all, just doing the math, 1 hour, 2 hours and 20 minutes. 3, 4. It's about a 4-hour hearing roughly, is what they have scheduled. With all that they have set up here, the first one is the only outlier that I think the defense is going to win. I think that he'll get to be in. I think there's a good chance that he will get to be in street clothes at his public hearings because of the notoriety of the case, because of the number of the people that are watching it. Jurors should not be watching this, or potential jurors should not be watching this. But if they do, it might help prevent them from having a bad idea about him before court begins. Then you've got the testimony of these two witnesses, which is all sort of tied in the method of execution. I think they're going to lose Barbara Wolf because she is there to provide a legal conclusion, which it's the judge's job. When it comes to Professor Cover, the defense might win this one. I think they might have. I don't know. Judge Higler has sort of allowed a lot of stuff. They might get both in, but I don't think they'll be strongly considered. I think they're going to lose arbitrariness. I think they're going to lose the strike the aggravators. On what grounds do you strike the aggravators? The heinous, atrocious, and cruel, utter disregard, future dangerousness, and multiple murders. These are just like facts of the case. Notice and proof of non-statutory aggravators. We'll look into that a little bit. Contemporary standards of decency. That's not going to fly because we know that the Idaho law requires the court to look at legislative action, not just public opinion polls. Speedy trial, lack of grand jury, and international law. Speedy trial is intriguing because they're saying we asked for a speedy trial and we're not getting it. But you also have to look at the fact that defense asked for a change of venue. And change of venue slows things down. And defense has been asking for more time. And the judge is saying, I'd actually like it sooner than that. So now for the defense to come up and say, hey, you need to throw this case out because he's entitled to a speedy trial and it's taken too long. That's what, disingenuous? Is that the right word? Tisha, 12 months with the little man in the corner who has the best YouTube channel. Thank you, Tisha. Thanks for everything you do for us, but especially for what you don't do. Tisha, thank you. Appreciate that. Unbalanced Equation, welcome to the gallery. Wonderful to have you as a new member. Appreciate that. All right. Let's see, settings. All right, so there we go. Let's remove that. Why is that not working? StreamYard. Doing funky things over here. Oh my goodness, it's not working. All right, good morning. Good morning. You might have an internet issue on your side. A lot of times YouTube will go blurry if it's not getting enough data on your download side. But we're pushing a great signal on my side, so... We've never really had the death penalty discussion on this channel that I can remember. You guys are missing out if it's blurry. I don't know. Because I'm pushing 12 megabits per second, 13 megabits per second of which is a ton of detail. That's double my normal stream size. So if you have slower internet, that could be the problem. Dive here. You want to dive into it? I'll do a quick synopsis of the death penalty. On the against death penalty side, the basic, you can boil down the basic argument down to two wrongs don't make a right. Right? If it was wrong to kill somebody in the first place, killing someone else doesn't make it better. That's pretty much the nuts and bolts of the argument. It makes the state murderers instead of just locking them up, which is the preferred method for most people who are opposed to the death penalty. On the proponent's side for the death penalty, they would say that the death penalty is the only punishment which has been 100% effective at preventing recidivism. That an executed inmate never comes back and reoffends. Any other method, even if you keep him incarcerated, could lead to additional crime. There's a cost argument because the process to execute someone is expensive for the state. We can break down the numbers. I don't have them in front of me. For each state, it's probably a little bit different. But if somebody is put on death row, if they are given a death sentence, there are a number of appeals which they are afforded. Many of them are automatic appeals, which puts a clock on the process that moves the hands very slowly. You've got risk of wrongful execution, but you have risk of wrongful anything in the legal system. Any punishment can be wrongful. So you're saying we're okay with Are you saying we're okay with wrongful incarceration, but not because that we can let them go? You can't give them their time back. You don't pay them. You don't give them money and say, hey, sorry, here's $1 million. Sorry, we kept you locked up for a year. That wasn't you. Turns out we were wrong. Our bad. That doesn't happen. But you definitely can't go back. There's no recourse if you have convicted someone wrongfully and sentenced them to death. Once they're executed, there's no going back at all. So I can see that's a big one. That's how that's just how I feel about death penalty. It makes the state just as bad. Plus, there's no 100% guarantee of guilt, and death penalty can't be reversed. Wrongful incarceration is terrible as well. Eighth Amendment. If you look at the arguments that's been presented here in the defense's case, they're going to bring this up. This is established already by the Supreme Court, however, that the Eighth Amendment does not violate, or the death penalty does not violate the Eighth Amendment's ban on cruel and unusual punishment. Because that's established, the Supreme Court would have to overturn it for that to change. So basically, this argument has been looked at, and it did not succeed. Now, Sloth Life, what we have with defense doing here in Bryan Kohberger's case today is saying we need to relook at the issue because public decency, public opinion, times they be a changing, right? People are different now. We're different people than we were last time this issue was looked at. Now we don't think the death penalty is appropriate, whereas before we did. So they're arguing that side as well, but I think they're premature in that argument. That argument may win overall. It may win in the long run, possibly with other defendants. But for it to win under Idaho law, at least, there needs to be legislative steps taken by states and by executive governors. Governors say commuting every death penalty. If that would be an executive step that would granting clemency to people who are applying for it because they feel it's wrong to have the death penalty, not necessarily because of the facts of the case. That would be something that the court could consider and say, yes, clearly public opinion is changing because our elected officials that the public have chosen, the person who is acting as governor is representing the entire state. They are saying that no, death penalty is not who we are. And once that starts happening, then that can change. Unfortunately, that hasn't really happened a lot. I do think that the number of death sentences that have carried out have lessened, especially over the last 50 years. You'll see a downward trend in those as it's sloping downward. So there's some argument for that, but I'm not sure if it's reached the proper point to make that argument to say that now we believe it's cruel and unusual, and we should revisit that Supreme Court ruling. Discussion is not easy. It's not, and it's difficult. The smartest minds in the nation and legal minds in the nation have weighed this and stewed over this and argued over this. Idaho did recently allow death by firing squad because they can't get the drugs. We talked about this Wu-Tang Flare. We talked about this the other day when we were reading the motion to eliminate the death penalty in this case for Bryan Kohberger, which is going to be heard. That motion is going to be heard today. But they argued this and said, look, yeah, you've in the books on paper, you've got the death penalty, but you can't carry it out. You've already got some case law set up that struggles with the way it's written, and so they're saying you can't do it that way. You can't kill them with the injection drugs because you can't get a doctor who, according to Idaho law, you guys need a certified medical doctor who is willing to execute their patient. And good luck finding one of those. who's sworn to the Hippocratic oath of do no harm. So they're basically saying you're in a tight spot. You can't kill him. You might as well just take it off the table. Current situation in Texas with Roberson is an example why the death penalty needs to be abolished. Convicted on bad science that we know better about. Chad Daybell is death row. He is. He'll be there for a long time. Still trying to, there we go. Hang on one second. We've got to make sure this is working properly. Audio. Okay, I'm going to have to go live on Top Market Media just for a minute and test some audio. But to do that, I need to pull up my own live stream. So now I have a loop.
Call from Denise.
Hey, Denise, how are you doing?
Good morning. I'm sitting outside the courtroom.
Are you excited for this one?
Oh, yeah.
How's the media presence this morning up there?
Poor.
Oh, really?
Yeah. I mean, at least it was when I got here. I'm the first one in line to go into the courtroom. There's 2-3 media ladies sitting out here.
Yeah.
There was maybe 1 or 2 cameras outside when I came in. So, I mean, to me, that's very poor.
Yeah. Well, part of the problem is that in this particular trial, cameras aren't allowed in the courtroom other than what the judge has. And they're streaming it on YouTube. So you don't have to be there to get it. So why send a satellite truck if you don't, or a live view if you don't need one? But I think
absolutely.
The arguments that are going to be argued today are huge for the case. Possibly some of the biggest decisions pre-trial that we'll see.
Mm-hmm.
So, gut feel. What do you think? You being local in the area, is the death penalty going to be on the table?
Yeah, I don't see it coming off. Unless the prosecution has done something really foul like they did in Valor's trial.
Right.
I don't see anything. I don't see it coming off.
Yeah. The hearing starts in about 43 minutes. I'm not sure. It might be about 20, 30 minutes before they let you guys in. Do you want to tell us what you're wearing so we can see you and say, hey, I know her?
I will. I actually have a picture, so I will send you that.
Okay, awesome.
And then you can share it.
All right.
Okay.
We'll do that.
Good morning. Okay.
We're excited for it. Thank you very much, Denise. When you're able to, give us a call and we'll talk about it.
I will.
All right. Thank you.
I'll talk to you guys later.
Bye.
Bye.
I love Denise being up there. It's a court watcher for us in Ada County, or Boise. Denise is our hero. Thank you, Denise. Iris, thank you very much. And Iris, thank you for 10 months of support. Here's the courthouse that we're waiting for to open up the doors and let us in. Denise, during the closed session, during the closed session, the very first part, which should take about 20 minutes. I believe what's going to happen is the judge will open the hearing, say, hey, we're going to talk about this, close the hearing, and it's going to be back to us waiting before, let's see, hang on. Okay, I need somebody over on Top Mark Media to tell me if you can hear me, and you can't. Okay, give me a second here. Okay, you should be able to hear me now with audio over on Top Mark Media. Is that better? And by Top Mark Media, I'm saying no audio on Top Mark now. Settings, audio, Blackmagic Design. Let's do computer audio input. Testing 1 2, testing 1 2. Can you guys hear everything on Top Mark? I'm loud and clear here. That's great. I'm just trying to make sure that we'll be able to get the audio from the live stream without my face on it. Worst audio ever. This is static. Testing 1 2. That's no good either. Now muted. All right. We're all good over here, but trying to get it set up over there is a challenge. Let me close this out. Stop the screen share. Okay, I've got to try. It's got to be Chrome. Why do I have different cameras here? Weird. Okay. All right. Test 1 2. We have an hour to get this sorted out, but I'd like to have it sorted out. Testing 1 2. On Top Mark Media, can you guys hear me? Testing 1 2. Big ol' Nope, nope, nope. Okay, I'm gonna switch to Chrome instead of Firefox and see if that fixes everything. All right, for those over on Top Market Media, not sure why it's not working very well. I might just have to record locally and then repost it. Was I buffering on this side? Okay, right now I'm sending audio, but I don't want you to have this audio when when Court was live. My idea was over on Top Mark. You guys can hear me now on Top Mark because I'm sending you my Roadcaster feed. My idea was to just have the Court feed, but StreamYard in their infinite wisdom have updated their system to not allow me to include audio from a share screen. Not sure why. See if I can launch a little application to fix that. What happens if I just give you channel 2? Okay, I've got an idea. Hold tight. I can route video differently. Output 2. Oh, webcam output is going to be camera 2. See, this looks good, right? And now I just need to make sure you've got audio. And I can do that by playing my stream on camera 2. Recovery Addict. Okay, so over on Top Market Media. Okay, so over on Top Market Media. Are you able to hear this? Okay, so over Market Media. Are you able to hear this? Okay, so over Market Media. Are you able? I'm not sure if you can hear me or not. Yes. But now I've got an inception problem. EDB says there's a lot going on and changing with StreamYard. I think they got bought or something to that effect, but she's also stated lots of things changing, not for better. Yes, first of all, they doubled their pricing and lessened their quality. Okay, so now do you just hear one of me over on Top Mark? Let's see. You only want Black Magic design. I'm not sure if I can just route audio from one source or not. We'll try. Sure if I can just route audio from one source or not. We'll try. Sure if I can just route audio from one source. It's like echo, echo, echo. We'll try if I can just route. All right, so here's what I need you to do. On Top Mark, I'm going to play this hearing, this lawyer disciplinary hearing from the other day.
The VA, I was...
And can you hear this audio? No. Man. Well, it was fun while it lasted. I'll just record it locally. Planier says, you think you got issues. A 16-foot of section of our fence blew down last night. Santa Ana winds in SoCal. Oh, my goodness. And you guys have fires down there as well, which is just terribly dangerous. Inception is not my favorite movie.
Rather difficult to adjust to
All
mentally.
right, so...
Because day in, day out, your mind is on top-level felonies. And because there's an allegation, of course I'm going to tell them. I have no requirement to tell them, but these are going to be men that are going to be my partners, hopefully in a few short years. I told them about this investigation. I told them, look, I didn't take the money. I did not steal the money, did not misappropriate, and I showed them the bank records. I tried to get this handled as quickly as possible so that they wouldn't be suspicious. And the fact that this drug on until the beginning of this summer, the closed-door conversations where you can't be here. You're not being honest with us. There would not be an ongoing investigation of you for misappropriating client money.
You can hear the court, but you can also hear my voice, right, over on Top Mark?
Because they saw the complaint. The complaint said you stole $42,000 from a client. That's not insignificant. Even the suggestion that that could happen, and the fact that the case remained open for that long, it was, you need to excuse yourself. We're not going to embarrass you by firing you, but you will not be here. And then I couldn't open my firm after that. And so I'll find some.
All right. So my brain is full, and I can't figure out how to make that work, so we're just going to skip it. We're not going to have a clean feed. Pretty sure Trial TV Live is going to grab a clean feed. I love that when you search for my channel, it says, you're not alone. Free confidential helpline. That's because I chose my name poorly. Let's see. Idaho 4th District Court. All right. We'll have it live on the Recovery Addict channel, and we'll go from there. I'm going to go ahead and shut down well, I'm just going to dual stream to Top Mark. How about that? There you go. Now you get me on Top Mark, and you get me over here. It needs your burner number. Burner number is 513-1160 with the area code 801. That is a Google Voice number. All right, as far as time goes, we've got about 27 minutes before court begins. There may be another 20 minutes after that where they decide whether or not Bryan Kohberger can wear a suit to court. I keep getting blurry. I'm watching, it's funny because I'm watching my own feed through Top Mark Media, and I'm not seeing it get blurry. So that might be an internet issue on your side. I am pushing a higher quality stream than I've ever pushed before now that I've got this better camera. So you might have slower internet that is struggling at the highest level of clarity. Going back to our schedule here for what's coming up, we're looking at we wanted to look at the speedy trial complaint. So I'm going to pull that up and see where their complaint of speedy trial was. You've got filings under seal. Request for appointment and transfer of case. What? This was on the 9th of last month. There's a resource judge. Not sure what that means. Let's see. Non-statutory aggravated evidence. Got the aggravators. Death penalty. Vagueness, international law. Arbitrariness. Standards of decency. Motion to strike grounds Speedy doesn't permit effective assistance. What? What? Hang on. I need to find the original. Speedy trial doesn't allow effective assistance. He wanted the speedy trial. Let's get down to Kohberger's. Okay. Kohberger, all the motions having to do with speedy trial. Order staying time for speedy trial, that was 7/7/23. Amended order staying time was 7/10. Motion to reconsider order staying time for speedy trial was 7/17. Response to state's motion to consider order staying time for speedy trial, 7/24. Waiver of speedy trial on 8/23. Okay, waiver of speedy trial. He's waived it. Order denying defendant's motion to stay proceedings and withdrawing order staying time for speedy trial. This has been an issue for a while. Objection to motion to strike state's death penalty on grounds of speedy trial. See if we can see what it says here. This is a response. So they must have filed this under seal. I think they filed this under seal, and now we've got a state's response, but I don't have the original listed, so it must have been under seal the first time. Comes now the state of Idaho by and through Latah County prosecuting attorney, and hereby objects to defendant's motion to strike the death penalty on grounds of state speedy trial, preventing effective assistance of counsel. Defendant claims that this court must strike the death penalty because he cannot be forced to choose between his right to a speedy trial under the Idaho Constitution and his constitutional right to effective assistance of counsel. His argument rests entirely on the inaccurate premise that the Idaho Constitution sets a hard and fast 6-month deadline for his trial. Because the Idaho Supreme Court has held otherwise, this court should deny the defendant's motion. All criminal defendants in Idaho have a constitutional right to a speedy trial pursuant to both the U.S. and Idaho constitutions. The right to a speedy trial under U.S. Constitution is assessed by the balancing of 4 factors. 1, the length of the delay. 2, the reason for the delay. 3, whether the defendant asserted the right to a speedy trial. And 4, the prejudice to the defendant. This approach has been adopted in Idaho for determining whether a speedy trial violation has occurred under the Idaho Constitution. In fact, the only difference between the federal and state constitutional rights to a speedy trial identified by Idaho Supreme Court is when the speedy trial clock begins. The clock begins for the federal right at the time of arrest, and for the state right at the time of arrest or the time the charges are filed, whichever occurs first. From there, both state and federal constitutional claims turn to the balancing test under Barker. Predictably, the case-specific balancing test adopted by the Idaho Supreme Court has resulted in a wide variety of permissible lengths of delay before trial. Delays from 15 months to 17 months to 2 years have all been found permissible under Idaho Constitution. Defendant attempts to free himself from this well-settled case law simply by opening that Idaho Supreme Court has wrongfully deviated from the right to a speedy trial as it was defined by the framers. He's going back to the original Constitution, as read on the parchment, envisioned it differently. He holds with this court to hold the decisions of the Idaho Supreme Court were wrongly decided. So he literally is saying the Supreme Court is wrong and you should overturn them. He asks this court to instead side with legislatures of other states and draw a firm line at 6 months. Unfortunately for the defendant, that is not how constitutional interpretation or law generally operates. The Idaho Supreme Court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. Once defendant's fatally flawed premise is corrected, his alleged Hobson's choice between the right to a speedy trial and the right to a defective assistance of counsel is not a choice a defendant has to make at all. In fact, the Idaho Supreme Court has expressly held that a constitutionally permissible reason to delay trial is so defense counsel has adequate time to prepare. That one's not going to fly. The speedy trial thing, this motion to strike regarding speedy trial is gone. Lack of grand jury, he's raised the grand jury issues before. Didn't like that it went through a grand jury. But then international law, let's see where that one comes in. Okay. Objection based on international law. There it is. International law. The objection, this part right here, let me highlight this for you. The motion to strike based on international law, right here. The motion is 481 pages long. $481 pages. Motion to strike state's notice of intent to seek death penalty on grounds of international law and memorandum in support of motion. So they attach 2 German laws. It sounds like it. Bryan Kohberger, Bryan through his attorneys, moves the court to strike the notice of death penalty, seeking death penalty, on grounds that Idaho's death penalty scheme violates its obligations under international treaties. Idaho's death penalty procedure violates the provisions of international treaties and the fundamental precepts of international human rights because traditional treaties ratified by the United States are binding on state courts. The imposition of the death penalty is unlawful. U.S. Constitution, Article 6, Clause 2. Lots of case law. Holy cow. It's like a paragraph-long citation. Mr. Kohberger also maintains that the failure to comply with international law violates his right to due process under the 14th Amendment to the United States Constitution, as well as Article 1, Section 13 of the Idaho Constitution. Now to the international treaties. Do you guys know, just a fun fact, what the first international treaty was? Or the first international, like all the countries got together and decided something? This is a research assignment. Somebody has to Google that. I think it was about birds. On December 10th, the United States General Assembly adopted and proclaimed the Universal Declaration of Human Rights. United States General Assembly resolution. The United States was among the 48 states that voted for the adoption of the Declaration. The vote was 48 in favor, none against, and 8 abstained. The Declaration of the first series of instruments prepared by the United Nations Commission for Human Rights. In 1988, the United States signed the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment and ratified it in 1994. In 1977, that was a few years ago, the United States signed the International Convention on Economic, Social, and Cultural Rights, but did not ratify it, and the International Covenant on Civil and Political Rights, which were ratified in 1992. The court is requested, pursuant to Idaho rules, to take judicial notice of these instruments. A true and correct copy of each of these instruments is attached hereto and incorporated herein by reference. So they copied all the international law. Here's a quick little bit from the International Covenant on Civil and Political Rights, or the ICCPR, which prohibits inhumane or degrading treatment or punishment. It prohibits the arbitrary deprivation of life, providing that every human has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of life. This isn't arbitrary. This is after a criminal proceeding where they're found guilty. In countries which have not abolished the death penalty, sentence of death may be imposed only for most serious crimes in accordance with the law in force at the time of the commission of the crime, and not contrary to the provisions of the present covenant and to the Convention on the Prevention of Punishment of the Crimes of Genocide. This penalty can only be carried out pursuant to a final judgment rendered by a competent court. The judge is going to say, I agree, and we are. And now they're talking about dissenting votes during the ratification. They are digging deep. This is crazy. Most importantly, this court must understand that the ICCPR does not permit what the Senate claims to have done. The whole country is wrong, and Bryan Kohberger is right. Our laws are wrong, and Bryan is right. This is audio is really distorted on top, Mark. I'm going to shut down top, Mark, then. Sorry, guys. Thanks for the fun. We'll zoink that one out. Okay. Maybe that'll fix the bandwidth issues. I wonder if Ann Taylor makes these arguments in all of her death penalty cases. Thanks for the coverage. Not sure. See if we can do a split screen so we can see as soon as something happens in... Let's do at least 2 boxes, right? Or 4 boxes? Missing my background. Okay. It's just plain blue, right? There we go. Box 1 is camera 1. I'll let you see what I'm doing as I build it, so it'll look a little, won't be quite as boring. I am working on the backside. Let's get this fixed. Box 2, let's bring in camera 2 here. That's going to be right up there. Box 3 is going to be our document we're reading. And box 4 is going to be our studio. How about that? So we've got our 4 boxes. Now I need to get rid of the background there by doing that. We'll turn this off. All right, now you can see everything. Now we're good to go. I use hardware, not software. I do differently. The hardware allows me to do things with the audio that software does not. And that is why I stick with it. Yeah, sometimes a little clunky, and yes, when it fails big. But you know, I can do things that are just cooler that way. Okay, let's bring in these guys. Let's swap. We're going to swap 3 and 4. All right. Time-wise, we're looking at about 10 minutes before court starts, and we'll bring that to you with all the goodness that we can. I will also be tweaking any audio the court does provide to make sure it's as clean and clear and loud as needed. Let's reset all our presets. Turn off all our limiters. No compression. Okay, we're starting with a clean slate. So if they give us good audio, we won't have to change anything. I will do audio magic as needed. If you look at death penalty transcripts, the majority of them all argue these motions, as the defense attorney is supposed to try every avenue. Right, this is not new. This is not a novel approach that she's taken. Everything she's raised, for the most part, has been raised before. Some of it a long time ago, and others more recently. Court audio is often through a potato. Yes, especially Idaho. Tammy's in Idaho. Enjoy, Tammy. I like Idaho. Idaho has some fantastic fishing. I'm not just talking like the Salmon River, but I mean you can catch a 10-foot sturgeon in Idaho, in the Snake River. You can also catch just amazing, incredible trout. They've got bass fishing, unbelievable. Just moved here, says Tammy. You're gonna love it. You're gonna love it. Plus, they border. They're right up there by. If you go up the corner, up past Rexburg and everything, you can get up through Island Park, which is amazing. Great fishing up there as well. If you do go to Island Park, you should rent the boat and float that river that ends up down at Island Park. That is such a fun little trip. Yes, I have a fan blowing in the background. Do you want me to turn it off? I've got my audio cranked a little hotter than normal. Now the fan is gone. Is that better? but now it's hot in here. Stop telling people about us in Idaho. Ashley, it's the only way I can keep them from coming out here to OBX. Jackson Hole is beautiful. Absolutely just stunning. Can never afford to buy property up there because you've got Jackson Hole, Park City, Vail, Colorado. These cities all are just like, they're the elite mountain communities. Am I in a courtroom? No, I'm in my studio with a courtroom backdrop. Great Dane, agree. Idaho is awful. Nobody come here. Please stay away. I like West Yellowstone, but I don't like Jackson Hole. I told you the Jackson Hole story, right? We sent. I was selling metal roof and wall panels, like metal roofs. We were selling those, and we sent some up to a large new construction place, and they wanted just like bare steel roof, which normally you don't run bare steel. You normally have protected layers and paints and things like that on it, but they wanted it to look old, and we put it up there, and it was too shiny. And the powers that be in Jackson Hole, they control what buildings look like so that everyone sort of fits the general motif. And they're like, your roof is too shiny, you have to tear it off. And our contractor's like, but it will rust. It's going to rust, and it's going to look really good. It's going to look old and everything. And they're like, no, it's too shiny now. It needs to be rusty now. And so the builder came back to us and said, help. What do we do? And our suggestion was have your roofers pee on it. And it works. It works. You pee on the roof. Pee on the roof. And it rusts faster. Yes, it ends with peeing. So, the Rust-O-Matic. I don't know what they did, but it did rust quickly. So, Babs, you guys have snow today. I saw that there's ski resorts opening in Utah. I think Bryan Ski Resort is opening, second earliest opening ever this weekend. Vinegar and Water works as well, but are you serious? Yes, that's what we told him. That's what we told him. But whatever, I'm out. So next time you go up to Jackson Hole and you see all those beautiful rusted roofs up there, you're like, huh, they peed on that one, they peed on that one, they peed on that one. All right, we're getting ready for court to begin here in just a second. As soon as it does happen, we'll bring it to you live with all the audio. I will move the fan. I want to move it back because right now it's in the way. I have to jump over it to get in and out of my desk. All right, fan is back on. It's just a little low-level buzz in the background. I did not see the interview with Melody's lawyers. I know she talked to Court TV. I can't air those interviews. A privately shot and conducted interview. The copyright's a little bit different there. It's a little harder to work with than regular fair use. I choose not to air those. One of Melody's jurors. What did it seem like their process for reaching a conclusion was reasonable? Was there a specific turning point? Because I didn't watch either of those interviews. It was reasonable. That's good. I would only be worried if they came out and said, yeah, we couldn't decide, so we flipped a coin. That would be a problem. Yeah, I did not see it, and I won't show it. So yes on both counts. Or no, I didn't see it. Yes, I will not show it. I'm surprised there's not more media presence up there with such a big decision being made. She said they all believed she could have dragged him to the burn pile. There wasn't any evidence that she dragged him. The phone calls with Rusty damaged her. It's an odd-looking building. It is a government building if I've ever seen one. It's like a cross between a school and a jail, which some kids will tell you what's the difference. But it's interesting. Sloth Life, get some rest. Hopefully you're feeling better here. Thank you. And thanks for the gifted membership as well. On the way out the door, giving a gift. Very kind of you. I appreciate that. Jinx, I was looking at that last night. I can't call your number. It's foreign. I have to say, honestly, it's the difficulty in, I don't know. It's going to be a challenge. It's going to be a challenge. I'm terrible to work with to begin with, and the difficulty in communication face to face, or me being able to call you and vice versa might be a challenge to work that way. But I did see the designs. I like some of the ideas behind them. Can someone please tell me what's footing with the Maya settlement? I don't know. Here's the problem, Robin. The settlement, the discussions, a lot of this is in secret. And like once they started meeting, and those ended, obviously, it got really quiet. And I don't know where we're at. Add to the situation that the relationship on the defense side deteriorated, and people left and fell apart and were fired, and there might even be lawsuits over it. I don't know. It's a touchy situation that I haven't wanted to dive into. I did check in with Dr. Joe during the last hurricane. The apartment, the little condo that he allowed me to stay in when I went down for the hearing, for the Maya hearing in Florida. They lost that to the first hurricane that came through, and then it got hit again by the second one. I don't know how badly their house got hit, but they got hit pretty hard. They were out of town, so their family is safe, but I don't know house-wise how they're doing. I don't know of any new lawsuits. I'm just saying that the way that the relationship with the Andersons and our Navy guy, why can I not remember his name? That it deteriorated. Whitney, the way they fell apart, I wouldn't be surprised if they, are suing each other. It got ugly at the end, really ugly. So I don't know where it's at. I just haven't wanted to wade in there. Diane says, my son says, I watched so much of your channel that any day now my law degree is going to come in the mail. Well, it's either that or internet ownership certificate. Those happen as well. What happened with Whitney? Disagreement about how things were being handled post-verdict. And feathers got ruffled, and he's no longer with the company. That's my understanding. I believe he got fired. Next thing to pay attention is J. Hatch brief by 3rd of December, or maybe a musical number. Yeah, it is sad. They went through so much together to see it fall apart. I think they were a really good team together, but they had, I guess you could call irreconcilable differences. We are a few minutes into when the hearing should have started, which means they might have started with the hearing being closed. It might be easier to start closed and then open it up as soon as it's able. The new judge for this, let me show you his signature because I think it's really cool, is Stephen Hippler. So this is, I believe, his handwriting. Stephen Hippler. S-T-P-P. That looks like you've got an S right here. I can see a T that he crosses, but then he does a hump and a wave across here, and I think these dropping down below the line are the two P's. P-P. S-T, P-P, and then a swoosh across the top. It's a pretty cool signature. Yeah, and the fancy 6th as well. With the underline. Oops. Looks like an S followed by a velociraptor. Yeah, just a little bit. Does the S look like a thunderbolt? Ooh, sharp pointed S a little bit. J. Hatch will come calling. I don't think it's going to be the first hour behind closed doors. We went over the agenda this morning that the judge put out yesterday, and it's showing that the first 20 minutes are closed. This is the only portion of the hearing that is supposed to be closed. Now, it's possible they might go into other areas that they deem need to be closed, but this death penalty stuff should all be public, and the rest of the hearing is basically death penalty in one way or another. So these TBD, to be determined, the reason why it's 20 minutes, I think they're going to have 20 minutes of argument about whether or not to hear the testimony. Then if there is testimony, this could add another hour or two to each section. So that would put us into tomorrow for sure if we heard from both on this to be determined. All right, here we go. Court will be beginning soon. We've got the live stream up. Ada County does a much better job with their live streaming than we got out of Latah County. As soon as it goes live, we'll bring it to you just like this, full screen. I might be in the corner, though, down here. Can do all the fun stuff here. How about this one? No. This will work the best, and then we can just enlarge or embiggen as needed. I'll be the little man in the corner, of course. Cue the Tetris theme. All the blocks fit together. Court will be beginning soon. Red pen. What's the official ruling on the phrasing here? Court will begin shortly. The two B's in a row, B and beginning. Seem funny. Reverend Beezy, did I see you? I see you sneak in here? Where are you hiding? We'll begin soon. Maybe we can all reach out and comment to the court and ask them to correct the wording. DMB second us. My next courthouse color will be beginning in 2 months. DMB, one of our OGs. There are a handful of you that will get the next color courthouse, and I don't know what it is. Does anyone know what next color is after orange? What's the 2-year mark? Which is just, first of all, that blows my mind. What is the 2-year mark color? It's translucent. Magenta.
Call from Jelena.
Jelena, this is RA. How are you doing?
Hey, I just wanted to let you know I finally heard from Reverend Beezy this morning.
Okay, we're live on the air. Is that cool?
Yes.
Okay.
He said I could share it with all of you. He's not gotten any sleep because of the puppies, and he has some serious vet bills, and has been superly depressed, kind of suicidal. So he said, please send prayers his way.
If this helps at all, he likes to see the the zebra you sent me, the emotional support zebra. I'll hang it right here today.
Oh, that'll be awesome. I will let him know that. I'm glad he finally responded. I've been worried, really worried about him. So, okay, that's what I wanted to let everyone know. So
thank you. It's got a lot of messages of support in chat for him as well. So.
Oh, I know. He's loved here. So thank you.
Thank you.
See ya. Have a good day.
Bye.
Bye.
All right. Wow. Hopefully, usually puppies help with depression, but a lot of puppies can be a handful for sure. Okay, here we go. He is in a suit. I guess that first one went well. Denise is in the green top, right behind Bryan Kohberger. Like straight behind. We're seeing it from an angle though. Looks like the prosecution and defense have switched sides as compared to what was in Latah County. I'm not sure where the jury would be seated, possibly to Bryan Kohberger's right and just ahead of him a little bit.
All rise. District Court is now in session. The Honorable Judge Stephen Pickles presiding. Be seated. All right, we are back on the record in Ada County case CR 0124316665, State versus Kohberger. Counsel are present, I think with the exception of Mr. Logsdon, is that correct?
That's correct, Your Honor.
And counsel previously identified for the state are present as well. Is Mr. Thompson going to be on the? Okay. All right. So Mr. Thompson is appearing remotely. This is the time set for a number of hearings this morning. Yesterday afternoon, I issued an order by which the proceedings would be handled, the order in which that they would be handled, as well as designating the amount of time, generally speaking, that the parties or that the court will devote to the issue. The court has received extensive briefing by both parties and has reviewed it all thoroughly. So the first thing I want to address, just because the public was not here this morning, I did hear information from security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohberger to appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes. The first matter we have to take up this morning is the objection to the testimony of Dr. Barbara Wolf related to the method of execution. So let's proceed with that. The state can be heard.
Your Honor, would you like me to address?
Podium, please.
Yep.
The podium means we get microphone. I appreciate the judge enforcing that.
Thank you, Your Honor. Our objection on this witness is really just the ripeness issue. We think that this claim is quite clearly several decades early at this point in time, and that's assuming that there's a conviction and imposition of the death penalty. And so we're just trying to save everyone time and would ask that the court find this issue is not ripe before we have an evidentiary hearing on it.
All right.
That's the extent of the objection.
All right.
Thank you, Your Honor.
Ms. Taylor?
She's going to have a little more to say about this.
Thank you, Your Honor. Your Honor, Dr. Wolf's proposed testimony is important for the court to hear and to think about the larger issue, and that is Idaho's inability to execute somebody at the given time. And there's a constitutional issue with having somebody sit on death row when there's no meaningful way for them to be executed. And Dr. Wolf's testimony will highlight for the court some information that may come up if Mr. Kohberger's ever convicted, and if there's a death penalty, and if he faces the firing squad as one of the options.
Well, I will say I'm not particularly convinced about your, well, I'm going to save that till we get to the merits of it. Let's talk about whether we need to hear from Dr. Wolf first, so I can continue.
Your Honor, I think that Dr. Wolf's testimony would provide the court with information about conscious pain and suffering, awareness of that pain and suffering, which matters for the Eighth Amendment, as well as why that information is known by her now. It's more recent information, it's after Idaho's history of having the firing squad and then removing it in light of the Bayes decision, and then in 2023 instituting it again. But this information about consciousness of pain and suffering happens in that window between 2009 and 2023, and I think the court should consider that and have that information. We also need to make a record in the event that there was ever a conviction in this case.
Thank you. Any rebuttal?
Very briefly, Your Honor. I would just note that the defense did submit an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
All right, thank you. All right. The court having reviewed the materials, believes that given the concerns about the current justiciability of the, or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be that would allow us to discuss the issue. And so for the time being, I'm not going to hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony. The declaration is an appropriate proffer. I will hear the merits of the motion based upon that proffer next. All right.
We're already 20 minutes ahead of schedule.
Hear that from the defense.
We just cut out the TBD.
Thank you, Your Honor. I would ask the court for leave to supplement that declaration. The information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf, that's not contained in the declaration. And I would like to make that part of the record too from her. So if the court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
You can submit that, and I will then hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor. Then moving on to our argument, and I will largely not repeat what's in our brief since the court has had a chance to take a look at that. We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody. When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
You say there's no means. Under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote-unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet in the sense that they couldn't locate a vein. I don't see how that issue is universal.
Your Honor, I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. Not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have their...
They have obtained them twice now, since then.
They've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure, as well as a recent decision by the district court approving that procedure.
You're going to main vein it.
And I think, looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bayes decision. When you think about it coming off in light of the Bayes decision, and you look at what's happened since the Bayes decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall, from the media at least, that construction is actually underway. But I may be wrong about that.
It should be done in time.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out, too. If you read our statute, and the court just summarized it, it's lethal injection unless it's not available, and then it's going to be the firing squad. But the way that's written is that it's firing squad unless the director of the Department of Corrections says, I have the chemicals and we can do lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose from, but Idaho's not allowing that. Additionally, the information that I think is really important to the court is to understand things and advances that have happened in understanding conscious pain and suffering. If Dr. Wolf had been allowed to testify, she would tell you that she relies on studies from 2010, a working group from 2010, and a book that was published later than that even, and that's post the Bayes decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist. Thank you, Your Honor.
Can I ask you, even if your motion were right, and even accepting as true that the current means of execution are either unavailable or would violate the Eighth Amendment as cruel and unusual, how do you get around Buckwell? You've not provided an alternate means of execution.
Well,
and I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way.
They have to have an
execute
alternative.
my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition precedent, provide a available or an alternate, I should say, means of execution.
I would say, to Your Honor, that we're not at the place where we would have to make that decision yet.
That speak to the justiciability of the issue overall.
I don't think it does. And I think that the separation and the difference is
so
that we are in a place where we're preparing this case to go to trial. We represent Mr. Kohberger, who sits there, an innocent man right now, but we're preparing this case as a capital case with all of the things that that involves, all of the requirements that are upon counsel that take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction, and if there was a death sentence, and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional? But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, I think that's part of why you're saying you shouldn't have to comply with Buckwell. But it seems to me that that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time?
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years when the way Idaho's doing it right now isn't really working. It's not a realistic option. I think to have him sit on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of your rights, I just don't think that the constitutional protections allow that to happen. I think that.
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe that the Troop versus Doles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety, it is fear, it is the not knowing.
I mean, to be fair, the Idaho Supreme Court just ruled that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read that opinion.
That was a ruling.
And I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No, but it was anxiety that was the underpinning.
I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Kohberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades to sit. And no disrespect to the anxiety Mr. Creech felt. I think that must have been horrible for him. But to sit for decades and wonder is a lot longer. And so I understand what the Supreme Court said. I did read that too. But I think it's different when you're just starting out here in this circumstance.
Okay. Thank you.
State.
Aye. Thank you, Your Honor. I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today, but I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor. I don't see a problem with that because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe it was hanging, and then after he was sentenced to death, the state passed a law, made it electrocution, and the U.S. Supreme Court said there's no ex post facto problem with that because you're not changing the penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this. And certainly not that it can't do this decades from now. And again, that gets back to the ripeness issue is it may be lethal injection, it may not. It may be some other method. But we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the ripeness doctrine exists. I also want to speak just briefly on the Bucklew point that the court brought up. What I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today in argument, what a proper alternative would be, which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it. If the state wants to pass a law and do this other method that he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless there's any further questions, we'd ask that the court deny the motion.
Thank you. Any rebuttal?
Just briefly, Your Honor. The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute. I understand.
Any case that says that?
I'm making an analogy with the troop versus Doles and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about 2 pieces of legislation to try to make this work, and it just doesn't work. So we're in a position where I'm not with a client that has a death warrant, and we're talking about whatever they'll probably talk about with Creech, with how they're going to do injection. We're not talking about the marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these problems with executing somebody. And how is that right, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument. That's it. Thank you.
Thank you.
So we're 40 minutes into this hearing. We're 20 minutes ahead of schedule still. I don't know how long the judge
We'll
rules.
take that issue under advisement, issue of written opinion with respect to its ruling.
He won't rule today.
Next, I want to take up the objection to Professor Kohberger's testimony.
The side that goes first is the one that filed the motion. This is the objection. So the state objected to the defense witness. This is also a death penalty issue.
Your Honor, as the state pointed out in its written objection, Professor Kohberger's testimony is largely...
Is it Cover or Kohberger?
I believe I'll defer to defense counsel. Is it? It's Cover.
Cover, thank you.
Thank you, counsel. Professor Kohberger's testimony in this case would largely center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony. The state cited to Ybarra in its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case where it was an almost identical argument, and the court found that it simply wasn't relevant, and also preclude Professor Kohberger from testifying on that basis as well. When the state received the PowerPoint that Professor Kohberger would be utilizing, many of these slides are simply excerpts from statutes. This PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her testimony would be, which is a constitutional analysis leading to her conclusion that Idaho's statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis. Thank you, Your Honor.
Pretty brief argument there.
Good morning, Your Honor. The first argument that I'd like to address relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was that they wanted a robust discussion about gathered data, analysis, and have that come under the scrutiny of cross-examination. And so that's my first point to you today, is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion to occur so that the data is and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study can explain it. The other point that I want to make is that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen did was nowhere even close to what the study that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively narrow the class of first-degree murders eligible for the death penalty. That's not a relevant legal analysis. The legal analysis is whether an individual aggravator does so, that it excludes rationally first-degree from among first-degree murders within that particular aggravator. And as I understand Hairston, it's just not a relevant issue. It's not a legally it's not an issue that upon which the question turns.
Well, Hairston was decided
that I'm a trial court and not the Supreme Court.
And I'm sorry I interrupted you.
No, that's
Hairston
okay.
was decided in 1999, which was a long time before Hidalgo was decided. And so the United States Supreme Court has absolutely made the issue ripe and said we want to hear what the specific data is, and we extend the invitation for that to be done. The study in Hairston was framed as, did Idaho's method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and capricious
That was the claim of geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It was based on money and whether or not an urban
That's
versus
different from
non-urban.
the issue of what the relevant legal framework is with respect to whether or not the aggravators are overbroad or over-inclusive.
I
as a
agree.
whole.
I agree, but before we get to even there, Judge, which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard, and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which is a legislative function that looks at the statute and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly inclusive. It doesn't do it based on, in fact, she generalizes the aggravators as quote unquote the fuzzy ones, I think is what she called it, and then the I can't remember what the name
Clear.
The clear ones
Right.
were.
Right, but it is her study is a good foundation when you're get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right, but I guess my concern is that the Supreme Court, the Idaho Supreme Court, has said that that's not the issue. When we look at whether the aggravators are unconstitutional as being not sufficiently narrowing of the class of persons or crimes available for the death penalty, the Supreme Court specifically rejected a approach that is based on the cumulative effect of the aggravators together. It said you have to look at each individual aggravator and ask, with respect to that aggravator, does it exclude sufficiently? Am I wrong about that?
I don't disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible
to
be charged with the death penalty. But it begins, Judge, with the definition of first-degree murder. You start with the definition, which is very broad, of first-degree murder.
Which is why the aggravators are required.
Right. And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Kohberger's article.
No, that's true, but it still comes to the issue. You still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
It's part of the analysis.
I mean, everyone agrees the statute itself as to first-degree murders that are eligible is, without more, unconstitutionally vague. That's why the court has, U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? And so then the question, the court has said, the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said, and other courts, not whether, when you look at all the aggravators together, cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first-degree murders from it? Does it narrow first-degree murders? And you look at those each individually and not cumulatively. My understanding is that Professor Kohberger's analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that, Judge.
Well, I've read our law review article, and that's what she says.
That's the purpose of having her
She's not
testify.
gonna
I
get to
think that
testify.
it comes in segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, pair it against what the result is for it being arbitrary and capricious. And when you're talking about our court, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
The other concern I have, I'll save that. I'm just now thinking about whether I need Dr. Kohberger. Why can't I rely on her law review article as a proffer of what her testimony would be?
Well, Judge, you are the trier of fact here, and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, the statute's overbroad, the aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court what her approach was, and it was different than what happened in Hairston years ago. And so for that reason, this court should hear that so that you can make a reasoned decision.
Good effort here, but a law review article is pretty solid. I think it would contain the argument pretty well.
Your Honor, I'd like to address the foundation issue, because even if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Cover's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case, and Professor Cover did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates this one in particular, and potentially others, as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that, in fact, that those aggravators did not apply. The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was labeled utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not to file that notice, again, she isn't even sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack. Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping. But again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Thank you. Rebuttal? Oh, actually, that was the rebuttal, wasn't it?
If you'd let me talk,
I will indulge you for
Thank you.
my schedule is already shot to hell, but we'll indulge you.
Judge, we will be able to get through in one day. I think that what the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. You know, when an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used those records, why the conclusions she drew were drawn. First of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data. If she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And so.
And that law review article was as of 2019?
Yes. Yeah. Yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
I think the judge is going to shoot this one down.
You brought up Hidalgo, and you talked about the Supreme Court doing this. My reading of Hidalgo is that cert was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not. Am I correct about that?
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. You know, other states have done the same at the invitation of the Supreme Court.
An invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted as an invitation.
Thank you. So I don't find that the proffered testimony of Dr. Kohberger will be relevant or helpful to the court to decide this issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of what that testimony would be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of law. Whether to allow expert testimony is committed to the court's discretion, specifically the well-known 4-part My Fun Life standard. Opinions as to the law are generally not admissible by experts. The court is the determiner of questions of law and not what somebody else's opinion of what the law is. Opinions of what the law is are received by the court through counsel, not through expert witnesses. And so generally I would not have permitted expert conclusions about the law. And therefore her opinions are neither relevant nor helpful, and therefore not admissible. Importantly, of course, as we've talked about, Idaho has opted to satisfy the constitutional narrowing requirements from the U.S. Supreme Court through the adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant, as I understand from reading her article, Professor Kohberger's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is whether a particular individual aggravator provides a principled basis for distinguishing between those who deserve the death penalty and those who do not. The Hairston case, I believe, makes that clear. The court is bound by binding precedent of the Idaho Supreme Court on this issue. And therefore, I don't feel the need to take Dr. Kohberger's testimony. I think the issue is sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up, I certainly can invite counsel and Dr. Kohberger back at a later date to provide that information or to help clarify some of that information. So from that perspective, I don't think Dr. Kohberger's testimony is needed this morning. Now, I'm not going to preclude the argument on the merits using Dr. Kohberger's analysis, because certainly counsel has the right to make a record of their argument on that as well. And so I will hear argument on the merits of the motion to strike the aggravators writ whole. This is not the argument on the individual aggravators, but on the collective aggravators.
So he's changing the schedule up. We're supposed to go straight to the motion regarding arbitrariness. Now we're talking about collective aggravators instead of individual.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. I will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
your argument doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation is in the selection phase.
That's what I'm saying.
So I'm not arguing about that. I'm going to step and grab my water.
Sure.
I want to be clear about the argument and eligibility that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well, and so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court. There's much more infirmant apart from the statistics that two justices relied on.
And I don't disagree with that, but it's certainly guidance for the court. You know, when you're not hearing testimony from the expert to explain everything that was taken into consideration in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse, and so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is the analysis by Dr. Kohberger in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line, but certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse.
I guess we're going to agree to disagree.
So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors, and I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of two or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or an other officer. So that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Tulipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other point that I want to make about our motion on this is the issue of geography, and I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harrison over financial resources, and the point was geography. It was in the context of arbitrary and capricious, and not in the context of equal
but
protection.
As I understand your analysis, is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Your client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's statutory scheme.
On the whole, your claim is that it violates equal protection.
They're attacking the system,
And,
not that it's bad in his case.
And not only on an Idaho level, but also on a national level when you take into consideration how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Interesting, I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho.
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside the control. Well,
that was Lori
not
Vallow.
Ultimately outside the control of the state, but because of the state's failure in discovery.
Lori Vallow.
This case, and then I believe there was another one up in the 2nd District relatively recently that then was resolved.
Yep. And I can't dispute that. That still does not eliminate the fact that in Hairston, Dr. Jensen concluded that there was a geographical issue, and in Dr. Cover's study, she made observations about geography as well.
But even she confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. For those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If
names.
I go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at cases since 2019 as well?
This is a trap.
You know, Judge, the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today, and not as of 2019.
Yeah, I guess I'm not willing to concede that. And if it was something that needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
time
opinion
frame.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is, if I were to engage in that, it seems to me relevant, at least as to the state claim claim that the state equal protection, not the state equal protection clause, but the equal protection as applied within Idaho geographically, would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but if you're taking the data from Hairston, which was 1978 to 1995, and Professor's Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it. We could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
I have a case that indicates that an equal protection analysis can be applied on its face as opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time, another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So, yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that. But I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logston has raised this issue, so I don't want to say you're the first.
In all of those.
Right, but it hasn't made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that because your client is from one of the geographic districts you claim is the
oppressed,
does not get its fair share of capital cases.
And we did not submit that argument in our brief.
All right, thank you. I think you've used your time.
Sit down, he says. That was a valiant effort. Spinning wheels, unfortunately. Doesn't need much from the state to...
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said, this just isn't how you do the analysis. You don't cumulate them and then do
What's
the
intellectually wrong with that analysis, though?
With cumulating and then...
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary.
Correct.
Why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you've found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody.
But if you have so many aggravators that on the whole would essentially apply to any first-degree murder, then isn't it just left essentially to the prosecutor as to which cases are or are not worthy to
that would make it arbitrary.
Bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly, it's binding precedent. The defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they've brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today. And the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason. And that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrowing requirements of Tulipa as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that, and instead they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on would you have to look at the data up to today? I think the question or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage, because let's say that courts engage in that conduct, and let's say that courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factors, so now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these.
We don't want to miss
questions
space
you'd
and
ask
time.
the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Hairston decision.
It's not necessarily a requirement you do, so I just wanted to know. You were fairly summary about it, and it seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief, and so.
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas because just as a matter of statistics, there's probably going to be more first-degree murders committed there and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions. Thank you, Your Honor.
Rebuttal.
Judge, I just wanted to touch on the issue that he raised about Hairston and the timing of that and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is I just wanted to point out some of that mitigating language that I'd referenced in Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. Clearly not something that's in Idaho's aggravating statute to consider. Whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. A statute that, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates amount to between 75 and 95, those years in Hairston, in 2002 and 2019 for Professor Covers. That's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing. Thank you.
Do you know what year the Capital Defense Fund was established?
It was after 95. And I think that Hairston may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that. But I don't. I just know it was after 95.
Has that mitigated the issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first-degree case. Because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you.
All right. I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we will adjourn after that.
All rise.
We got a short break here. Meanwhile, I got a cable. Cable arrived. I think this will work. That allows me to control my camera from my switcher, which is really cool. Camera control for... Should we test it? Why, yes, I can. I've completely made a mess of it, but yeah, look at that. Yeah, I've got full control. We want to get rid of the white. Bring up the gain a little bit, but not too much. Keep the blacks pretty dark. There we go. Let's see what the gain does. Crank up the gain a bit. Doesn't get grainy. Our shutter speed's okay. I can mess with all the hues and the colors. Anyway, can I remove the guy in the corner? I can. Boom, he's gone. Now he's back. That's me. I'm happy to have control of my camera again. That's really good. Of course, it's a little bit blue. All right. The way this is going so far, if we look over at the, let's see, let's put this up on full screen, shall we? On camera 3. If we look back at the agenda for what was on the plan for today, first of all, the public hearing regarding street clothing scheduled for 20 minutes. The state did not object to that. They had no objection to him wearing street clothes, and so they're like, okay, well, that's done. Now we move on to the open session, and they started with the testimony of Barbara Wolf. That was thrown out, as we suggested it might be, and as the state argued, she did not get to testify. That saved us whatever the TBD time was, but the testimony itself was done in just a few minutes. We went on to method of execution, which was done in a short matter as well. We started at 11 o'clock. So we should have been, looking at the timing, there's 20, 40, 60, another 20, there's a minute, or an hour and 40, arbitrariness. I'm not sure if we've handled the aggravators individually yet. We've handled the arbitrariness of them going with the death penalty, meaning just whatever they choose. And we talked about geography a little bit there, where I think we're still about 20 minutes ahead of schedule. So we should be 1 to 2.5 hours in. I know we're 1.5 hours in. So yeah, we're gaining time. This will not take 2 days. We still have a couple things on the schedule, depending if we're going to hear more about the statutory aggravators, the heinous and atrocious, utter disregard, future dangerousness, multiple murders in specific. As well as the non-statutory aggravators, the standards of decency, the speedy trial, lack of jury, international law. I don't think that's going to take all 30 minutes because I think those are not solid arguments. And then the motion to trifurcate. So more stuff happening. Did the judge rule on anything? Yes. He ruled that for now he's not going to hear the witnesses that are going to talk. He's not going to go back to. He's not going to hear the testimony from the witnesses that wanted to testify in support of the defense's motions against the death penalty. He says, I've basically either what they want to say they can't say, meaning the witness is going to make a legal conclusion, which is my job as judge to do. So I'm not going to listen to that. Or he's like, basically, I've got all I need, and it just doesn't apply. There are objections due to the ripeness of some of their arguments, which was at the very beginning, basically saying, isn't this something you should bring up after he's convicted? Not now, because there will be a lot of time between now and when he's really going to face the death penalty to say, hey, we don't have a method right now to kill him, so thus take it off the table. Speedy trial. Why she had him stand in silence. I knew it would be a revisit, says Nursey Dog Mom. Yeah, she's smart, but I don't think it's going to win either. You look at the motions that she's filed for the change of venue. She's asked for more time for for a number of things. She keeps raising the issue about how much evidence there is to review, how many terabytes of data they have. At the same time, she keeps asking for more. So it's sort of funny to hear that. But she's doing it in such a way that she can make the argument which we expect to hear this afternoon, which is that the speedy trial makes it so it's not enough time. It's too narrow of a window for us to provide an adequate defense. Now, he's entitled to a speedy trial, but he doesn't then get an adequate defense. So you should, dismiss the case? What? No, Idaho case law already has on the books that if they need more time to prepare an adequate defense, that does not violate speedy trial, even if they add like 2 years of time to it. So I don't think that's going to go anywhere. But they will bring it up. I like water. It's good for you. Lots of losing arguments. The things the judge has not ruled on yet, he appears to be on the state's side on. I'm not sure if it's good. I probably should have muted so you didn't hear me gulping that down. I'm not a camel. That's good timing on that one. Water tastes gross. Now, I like to say I'm thirsty, not dirty, when I don't want water. But I drink my water without swallowing. I've never been able to do that. I know some people can just like open up their throat to their stomach and just pour something in. I don't have that, I don't know, skill. I'm super excited about this new camera. Man, it's just working well. ASMR water chugging. You can only do a little bit. If you drink too much water, it's actually bad for you. So you can't do a lot of that. I think people have died from it. I think we've had court cases about people who have died from being forced to drink too much water, generally with children. So, all right. How long is the court away? Just about a 10-minute break for the judge. Give everyone a quick break. I try to drink 5 of these a day. This is 500 milliliters or 16.9 fluid ounces for those of us who don't know what that is either. I drink water like I'm Daniel Plainview at the end of There Will Be Blood. I have not seen that, but there's a visual in my head that I just created. Couple things. I've seen a couple comments here about, you guys have already convicted Bryan Kohberger. We haven't convicted him. I would say I have not convicted him. I would say there appears to be a lot of evidence against him, enough to definitely take him to court and try him. But he is innocent unless proven guilty in court, and that is going to take place. The court, that portion that is, it may end with him being proven guilty next year, which we're going to follow. Thomas is just sending me the picture of the water bottle that he has, which is much larger than mine. But you don't have Deer Park. I'm just saying. Crystal Geyser, it might be good, but I've got Deer Park. Thomas, looking forward to the podcast tonight. On this channel, 8 p.m. live podcast with Thomas and myself. We're going to have some fun. I've got a picture to send you, Thomas, as a matter of fact. I'm going to send that now. All right. You can drown from drinking too much water. Ugh. Water drops your sodium levels. You have seizures and die. I don't like scary movies. It makes me so I can't sleep. Is it a scary movie? Like full of jump scares and stuff? I will show you the pictures I've got of Reverend Beezy's puppies here. Just give me a second here. Let me... So we've got, no, that's not going to work. We're going to have to go. We've got how it started right here. Cute little puppy. How it's going. I like the zebra as well. And then there are more and more and more of them. And now we've got just paws and little cute noses everywhere. So. Josh, is this some sort of joke? Is it? "43 monkeys escaped in South Carolina, right next to an Amtrak station, and they were thinking that the monkeys are going to hop the train." 43 monkeys? Who has 43 monkeys? Or who had 43 monkeys? Police searching for 43 monkeys escaped in South Carolina. That's a troop. That is a troop of monkeys. That's wild. A research facility. Oh, good. I'm not a big fan of research on monkeys. Monkeys fly, no need for train. I saw that movie too. Wizard of Oz. It's a platoon. It's a platoon of monkeys. I wonder if they can like live in South Carolina. Hey Amber, how are you doing?
I'm good. How are you?
Have you called to talk about the monkeys?
I did.
So a research facility, what? A monkey stole the key and they got out, or?
The pretty smart creatures. I just wanted to make sure that you had Mrs. RA or one of the little RAs go check to make sure all the windows are up, the doors are locked.
Planet of the Apes in South Carolina.
I mean, they could come visit you.
This is a concern. I'm just curious. South Carolina does not get freezing cold. I'm wondering if monkeys can like, yeah, I'll make a go of it here. This is good enough. Can they live? I mean, what's their food source? Bananas? Bananas don't grow in South Carolina that I'm aware of, at least not on large
No, but
scale.
they can wander their way. I mean, police stations will get the phone calls from grocery stores that they're being raided by monkeys.
The whole troop comes in and just cleans out the fruit section. Here's what I'll say. These monkeys, okay, if we've learned anything from Peanut this last week, right? These monkeys should not be euthanized if caught. Right? They've earned their freedom, but at the same time, they should not be sent back to the research facility, who's already proved they don't know how to care for their monkeys. They can't even keep them in the building.
Yeah, I wouldn't want to be the guy that had that job to make sure the door was locked.
I thought you locked it. Oh my goodness. This actually happened in Florida, and there's colonies now. That's what I'm saying. Are they establishing a local population? I mean, if these were tilapia, if these were like trees living tilapia, which is a fish, so that doesn't happen. But tilapia can like triple their population every 3 days or something. It's nuts. Of course, it goes over a larger scale. They breed like every 30 days. But I'm wondering how fast.
Look at Josh's comment.
I wonder how fast monkeys can. Dollar General's right next to the facility, so they made a stop and hopped on the Amtrak, headed north. I don't think they go north. I think they go south, where it's warmer.
So I think I've told you before about a wild animals, but I mean that's an exotic animal, I guess you could say. So in Suffolk, Virginia, part of Hampton Roads, there was a overturned tractor trailer one morning on my way to work where they tried to take the exit that would take them into Smithfield. You know, where Smithfield Hams is at.
Smithfield is a pork production location.
Uh-huh.
Yeah.
So there were piggies all over the interstate.
Big pigs, like harvest-sized pigs.
Big pigs.
They're
And the
giant.
driver, I watched as he corralled or was trying to corral big pigs because his truck tipped over. He took that turn a little too sharp. So that's what this reminds me of.
I think the truck was probably driving just fine, and all the pigs were like, "Everyone, step to the left now!" And shifted the truck, and it worked.
Oh my gracious! I think it's hilarious because law enforcement's telling everybody to
Lock your doors.
lock your doors, close your windows. Did they say keep the kids inside? Just in case.
Well, clearly, these monkeys must have been mistreated. If they're being looked at as like a threat, they're like, well, we trained them by the way we treated them. And now you all look out, because we weren't nice to these monkeys. And now they see people and they're like, oh, yeah, I know what you do. And
Oh, look at my cat. I didn't know what kind of monkeys, and all I saw was the glimpse of that thumbnail.
this is an actual photograph of one of the escapees, I think. That's the kind of monkey. They're cute, but
Comment.
I'm not going to say. Oh, I was going to read the comment and not say the name. Now that you said the name, I can't read the comment. Wow, this whole story is bananas. That's funny, Mark.
I said, "Oh, please do."
Okay, someone, I'm not going to say who, somebody said, looks like my ex. Looks like my ex. Man, okay. This is my concern.
I gotta go.
Okay, Amber, we'll let you go. See you. Bye. Here's my concern as we're about to come back to court. What sort of testing were they doing? Were they doing like strength testing? Were they like injecting them with radioactive materials to see if they could, make super monkeys? Do they have some sort of virus? Are they testing medically? Are they testing, drug resistance? This is how so many movies start. So, yeah. New fear unlocked. Monkeys. I'm going to listen to the scanner and see if we've got monkey business happening down there. Did anyone say what county that was in? Is it York County? Yemassee, South Carolina is Beaufort. Okay, Beaufort. Okay. Apparently, I have to watch an ad for Temu before I get to listen to the police scanner because I don't pay for the expensive one. Okay, we're coming back. Here we go.
All right, I think we are on now the motion to strike the individual statutory aggravators. I will give each side 25 minutes and you can address them.
We're on item 6 on the agenda.
Portion you like within that.
Heinous and atrocious, utter disregard, future dangerousness, and multiple murders.
Okay, Judge, I will be covering heinous, atrocious, and cruel, utter disregard, and then I will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next 3, and given the time that you've asked, I'm assuming there will be less questions, maybe?
I will try to restrain my curiosity.
All right. I'm happy to engage with you.
I, as you know, I gave you some additional time, and that says why.
Right, thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Hervé versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show, or the distinctions, is that, you know, Hall was a decision was issued in 2018. So was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, this court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction. And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator, as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than it was in Hall.
Ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw a distinction there. I think that they're, similar. Yeah.
So let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth, I think it takes longer. They can take notes.
So utter disregard falls under the same argument. The one thing that I want to point out about utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel. Which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raise the argument there that it's a separation of powers violation when there is construction on that statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator.
Multi-victims. How are you going to get around this in that there were multiple victims?
Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear, 1 + 1 = 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree. And,
right.
Right. And the floor is pretty high, but what I'm saying, doesn't that bring you above the floor?
Judge is not giving us the bird. He's holding a pen.
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so, just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's, the method of selection with a jury and the rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi-victim aggravator and you also have a propensity aggravator. And there's been, as we cited.
Is that a constitutional problem or an evidence problem?
Evidence.
It becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators.
Juries don't treat people charged with multiple murders very lightly. That's what they're getting at. They say don't tell the jury, don't instruct them about multiple
I
murders.
also wanted to point out that there are multiple states with the multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related to propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime, and then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Okay, Ms. Taylor steps up to address the future dangerousness issue.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. That, I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing, or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great by the language alone. And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, that doesn't help. That just says people.
Did Hall say that it was okay? I can't remember if they addressed that in Hall. I think
Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you are to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer. But this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And
isn't that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this. But now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the 8th Amendment.
Thank you.
Future dangerousness. If any of them, if they do win on any of these, this seems to be the most likely for me. Heinous, atrocious, cruel. I think, yeah, those are pretty descriptive of the crime that he's alleged with committing.
Your Honor, beginning with the heinous, and atrocious, and cruel, this aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was Hall a jury determination? Do you know?
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall that.
I'm the
that
judge
issue hasn't come up, but
handling the
Your
appeal,
Honor.
and I don't remember if it was a jury
And
or
I
not.
apologize. The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all, and that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial gloss. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Jurek versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on an independent basis for each of these aggravators during the penalty phase. That's our legal obligation, and the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
And the last but not least.
Judge, to answer your question about Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
So now multiple murders. Let's address that as an aggravator.
I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislature's, not the judiciary's. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death-qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity and those two so overlap that you can't have both, you could still have one. Or you could have both, but if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death-qualified jury, because death-qualified juries are highly likely to convict in the guilt-innocence phase. So we are very, very concerned about that and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi-aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Her argument is juries that have been qualified for the death penalty tend to convict.
I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be likely, or is probable that they would kill again. I think is the way that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there. So when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, that's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction or with this aggravator. It needs to be fixed. But the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
So they want the judge to decide instead of the jury, but he chose a jury trial, not a bench trial. He could have literally had the judge make this decision if he wanted a bench trial. Kohberger getting a little help with his collar. He's out of practice as he's not worn these clothes in quite a while.
All right, I think the non-statutory aggravators is the next issue for our attention. And so with that, I'll hear from defense.
We're slotted for 20 minutes on this
Judge.
discussion.
Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the for the state on that issue?
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
All right, next.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being...
So if you look at it like a scale, right? And the defense puts on evidence of mitigation, and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
Yes, Your Honor, and I think that that's clear from the Hall decision when they talked about this. They talked about they talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case, it's important that the jury have a wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process. I guess my point is I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the aggravators?
I think the visual using my scale would be to get on the scale, the statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented, when weighed against each statutory aggravating circumstance proven by the state, are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance, and that's the point where these things would come on the scale, to use your analogy. And so I just don't know that there's a point where you would instruct the jury, you know, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. You know, they would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigating beyond a reasonable doubt. So my point is, both in the mitigating evidence and in this non-statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. Now, we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for, and I think that that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper as to what gets heard at all. the fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand, I don't know that that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
Little rebuttal here.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, it talked about, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters, but it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Thank you.
So this is any evidence that would not be going to those statutory things of heinous, atrocious, cruel, utter disregard, future dangerousness, or multiple murders. They're trying to keep any other evidence out that might say, yeah, look, it was a bad one, guys. It was a bad one because of XYZ. In addition to those 4 statutory, they're trying to limit those. I don't think they can. And the state's like, I don't even know what the evidence they're suggesting.
8 and 9, just because I could see 8 potentially going a little bit longer than 9, and so
8 is speedy trial, lack of grand jury, and international law.
Yeah.
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling, and I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
So he's not here. All right, well, let's start then with 8, contemporary standards of decency.
That's the one that Mr. Logston
would
be here. I've got Speedy.
Would you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start
with Speedy.
I can do that.
Apparently
Thank you,
that's
Judge.
the only one they can begin with. Mr. Logston still driving to court. Must have driven to the wrong courthouse this morning in Latah
Your Honor,
County.
we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights. And those were effective assistance of counsel or
right to
speedy
testify
trial.
or right to stay silent.
Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial, in the same time frame that the statute, 1935-01, says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm sorry.
So it seems that you're asking the court to
Thank you, DSM.
equate what the statute said about speedy rights before the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance because there was that the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months, but I think our statute does now, and our statute derived from an older statute, and I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023 when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes the time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of speedy evolving on a sort of good cause basis. I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different, and as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remittitor was issued and when the case went to trial, and that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment, they do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute, to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights.
How is this any different than choosing between the right to remain silent and the right to testify in your own defense?
Should strike the death penalty in this case based on the record
that would
here.
result in the death penalty being struck in every case.
Yep. She's
Your
okay
Honor,
with that.
if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been doing...
The Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area.
That was the best answer.
I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the, be more flexible given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not.
Well, that's what you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job as a district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
Well, I think you can consider what Judge Boyce did in the Vallow case, and that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would disadvantage the client. And so Judge Boyce in that case struck the death penalty.
But that was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not. And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. But in this case, the decision to waive Speedy was not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived Speedy, we advised the court and counsel that this motion this day was coming.
It did.
We don't think
We
it's
knew this.
appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived Speedy trial. And so she had the choice to waive Speedy or not face the death penalty. And we think
We want that same choice.
Since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Wow. Bold assertion, but I think that the argument here, there are competing constitutional rights that you have to choose.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays there were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case...
Well, and that was my point in, perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm saying this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within the, at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. That was the speedy right. And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right. And it is engrafting that statutory construct to mean the constitutional right.
Potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today. Because
my point is that's, I think, what this defense is arguing, essentially.
Yeah. Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period. And regardless of whether they want...
The argument that the 6-month is functionally equivalent of the twice-a-year circuit.
If that is the argument, I don't think that it gets past the Idaho Supreme Court has said, no, it's not. So... under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible, and one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Just briefly, Judge, we're not trying to graft in a time into the Idaho Constitution. We're looking at the word, the guarantee for a speedy trial, and trying to figure out what the word speedy means. And so,
Well, doesn't speedy mean the Barker test?
well, at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
Yes.
I think our Supreme Court does agree that it's the Barker test.
Again, I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you're just going to trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. So that's it.
We're going to take this one under advisement too. Your Honor.
Right.
Are we going to jump to number 8?
That, along with the other motions, will be taken under advisement.
Ruling to follow.
Take a lunch break. It's 5 to 12. Adjourn at 1 o'clock. Thank you.
So we have a 1 hour and 5 minute lunch break. We can take this lunch break as well if you'd like, but it's already late in the afternoon. I wanted to point out a little bit about the laws. The defense team has talked about this evolving state of the laws, and yes, they have. Yes, they do. Going back, for example, going all the way back to 1700 BC, Hammurabi's Code. There were 25 different offenses that you could commit that would make you eligible for the death penalty. Things like adultery. You cheat on your spouse, that's the end. Helping a slave escape, that was the death penalty. A false accusation. Robbery. Theft. It was capital punishment, first offense for all of these things. We've evolved quite a ways from that. Specifically, theft. We generally don't kill people for stealing things now. As a matter of fact, a lot of times there's sometimes not any jail time at all for that. It's evolved quite a ways. Adultery, on the adultery one, we don't kill people for adultery. We've evolved so that now the spouse just kills the cheating partner. And then we have the murder case for the spouse. So we've got a little bit of a change there. We're not that far from Hammurabi's code, but it has come a long way. There is an element, though, of when you're looking at the law, that of justice, right? That what is fair, and what is fair, and we look at this in the eyes of what the victim lost, and then we go, okay, so looking a little more modern than Hammurabi's code. We've got biblically, we've got eye for an eye type law, right? The law of Moses type justice, where if you chop off your neighbor's hand, we're going to chop off your hand. Make it all equal. Everybody's fair now, right? It's all equal, and there are strong elements to that approach to the law that still exists today in society, where you say, okay, you've got somebody who drove drunk and crashed into a family and killed 3 of the kids, and he gets 8 months in jail, right? And the people are like, how's that fair? How does he get to get locked up for 8 months and then get out and just live life? The 3 kids he killed don't get to. Where's the balance there, right? Where's the balance? And I don't know. We like to think that we're better, right? That society, we are better than the person who committed the crime, that violated the law. If we're better than them, we think we won't stoop to their same level. They killed someone, but why is it so dark in the studio? Because we're talking about the death penalty. I've just been playing with the camera settings. I can crank the gain up if you'd like. Can make it lighter. Is that better? Is that better for you? Turn this down a tiny bit. There we go. This is dark RA. RA after hours is what we call this. I imagine, looking through chat, I saw elements of this. I was thinking, you see people who say, you've got this defense attorney arguing, oh, you can't have the death penalty, it's cruel, it's inhumane, he would suffer. The anxiety of not knowing how he was going to be put to death is just, it's unconstitutional to make him suffer like that. And somebody else is saying, I think the victims probably had a bit of anxiety too. Where are they in all this, right? Where's the equal sides? I'm still very blue. Should I be less blue? Is that too blue or more blue? I'm blue and Abadi. Yeah. Let's see. A little more red, a little more magenta there. Does that work? I think it's the green is throwing it off. Hey Siri, change my lights purple. Okay. Boom. There we go. Amber says, can you just take a peek at Mod Chat? Wow. I may, at some later point, I might give you guys the ability to change the color behind the TV with a command, but we'll figure it out. I'm a little blue. I just haven't had time to play with the camera. I need to adjust the gamma, the lift, the gain, everything. I'm still trying to figure it out. There's no punishment that can compare to the suffering of the victims and the families. Okay, so here's our thought process. Do we then say, if the punishment can never make it right, what is the purpose of the punishment? If it doesn't fix it, right? It's not going to make it everything okay again. We can't bring back the people that were harmed, the people whose lives were lost. Does taking another life make it better? Or are we strictly focused on rehabilitation? Saying, oh, this person was broken. He broke the laws clearly because they're broken. We're going to teach them, medicate them, treat them, do whatever we need to do to bring them back so they can be good and productive and law-abiding citizens in society, and thus release them. I like the purple. Yeah, I've got some weird colors going on here. Hang on. I'm not opposed to a little bit of a darkness in the stream. But this is too much. Let's see on gamma. A little bit of gamma, a little bit of gain, a little bit of gamma here. A little less. Lift those blacks. They're too purple.
Call from
the IRS.
Who gave you this number? Just kidding.
Don't worry about any of that.
Hey, how's it going?
How's it going, everybody? How we doing? I just tuned in and saw you were having a little rave with your light show here. Figured I'd...
Boom. Yeah, I'll turn up the bass. Oh, you're so much better at that. Drop the beat. I'll start the rhyme. Okay, go.
So I think I just caught the little tail end here of the little Kohberger, scenario, and I like the questions that you're posing to the chat. It seems to me it's a philosophical debate in a sense that what do we consider the law to be? The court to what's the purpose? Is it to provide retribution for those who are affected, or is it to remedy future instances or occurrences? And I think there's no bigger debate or no bigger quandary when it comes to that question than when it comes to capital cases and cases where there is real life, breathing victims, or in this case, not so breathing victims. Is the purpose of the court to punish the offender or to lay a message for future perpetrators or potential perpetrators, or is it a balance of both?
I think it's a balance. It's got to be a balance. If there was no deterrent, there is a deterrent factor. It's like, hey, if you steal, you're going to go to jail.
Sure.
People have to know that last guy who stole, he went to jail. You're going to be no different, right?
Sure. The reason, I think the place where that gets sort of muddled up and loses its effectiveness is the difference in penalties based on certain criteria where it leaves a gray area, right? Like where certain groups are punished to a higher extent than others, where people with money are punished to a certain extent than others, or less extent than others, where other mitigating factors muddy that up to where the deterrent becomes more of an issue of where you started before the crime was committed as opposed to the crime that was committed itself. So I think that's where that philosophy loses its sort of effectiveness, is when people see that isn't always carried out, 100%, or it's not always consistent, I should say. So,
well, that's where the Supreme Court comes in and tries to balance this all out, right? That's why we're saying, hey, there are some counties that you're overcharging, and there are other areas that you're not. That argument was raised here in the BK hearing today.
I have a more vigilante approach to the law, where I believe the purpose is I believe more in the punishment of I believe that the law carries, and it's going to come out wrong, but I believe that the law does carry a certain sort of retribution effect or purpose to it, where we are providing the people who were affected a little bit of relief so that they do have, because that's their last chance to have a voice, right? Aside from doing anything crazy or going rogue on their own. And so they're counting on the court to offer that bit of evening of the scales, eye for an eye sort of mentality. They're counting on the court being able to dish that out in a legal, most humane possible way, that they don't have to take it into their own hands. That's all they have left.
Because it's not legal for them to take into their own hands. They would be violating the law themselves, and the court is the only place that can execute that justice in a manner that is legal.
Right. So they're counting on the court being that last, sort of hammer that can come down and offer them some kind of solace to issue that bit of, I don't want to use the word revenge because it's the wrong word, but you know what I'm saying. Like they don't have any other they don't have any other avenue. They don't have any other place to go. So they need the court to issue that hammer. And I think that is most, obvious and most prevalent when it comes to capital cases, which I think is the whole point of the death penalty anyway, because statistics show that the death penalty does not deter murder. It does not deter the taking of life at random or otherwise. And so to me, because that's true, it would seem to me that the only or one of the heavy reasons that we still offer the death penalty in certain cases is to provide that evening of the scales for the families or for the loved ones. I don't know quite what the argument against that is if it doesn't seem to deter future instances of murder.
I would say it does deter future instances of murder from that offender.
Well,
100%.
Well, right, but the argument would be made, the counter argument to that would be, and me of all people dislike making this argument because I am pro-death penalty, but the argument against that would be, so would locking them in a cage forever. You know, who are they going to hurt if they're, locked away for good?
In solitary?
Well, not solitary, but even in a...
if they're not in solitary, they tend to, and still do, kill each other in prison.
Well, you don't have to tell me.
Yeah.
Touche.
Yes.
But my point is that the general threat to the overall public is going to be almost mitigated to zero by having that person incarcerated for the remainder of their natural life, which I never understood that phrase. What is your natural life? What does that mean? Are we suggesting that there is a possibility of a prison resurrection? What are we talking about here with natural life?
Just that till you die of your body's own, just till your body dies of its own without outside stimulus or interference.
Okay. Well, not to get too off track here, but you know why I don't want to be cremated?
Why is that?
Because if there is a zombie apocalypse, I want in, one way or another. I want to participate, and if you're cremated, you rule out any chance of being on either team.
I hope to be on the other side of that apocalypse.
But anyway, I just thought I'd throw some nuggets out there to chew on.
Ivan, it's good to hear from you. Hope you're doing well. Still need your advice when it comes to Bitcoin, which is doing fabulous, by the way. Everyone should have bought 10 years ago.
Surge past 76,000, looking strong, and the mood around the Victor estate is a very jubilant one, as you can imagine.
Yes.
Sure. But I will give you a buzz this weekend, Saturday.
Sounds good. Thanks, Ivan.
All right,
good to hear from you. See ya. Bye.
Yep, bye.
Good stuff. Zombie apocalypse may be upon us. Let's see. No, you come back as a smoke monster like in Lost. I guess there are options then. You can either be on the Team Zombie or Team Smoke Monster. I hated when I, being directly affected by a person's crime, see them get more rights than my family member. Just saying. Okay, Pretty Eyes, I see this. Especially when the defense is like, hey, that's not... He has anxiety. He's anxious about what might happen. Do you think there might have been a high level of anxiety, as there's indications that some of the victims attempted to fight back against the crime if he committed it? I'm just saying that if he committed it, shouldn't the state be able to go forward with the death penalty as an option if he's convicted? Ivan's now Team Zombie forever. The victim had rights. They were violated. That's why the accused is on trial. But now we're focusing entirely on the accused rights. And I realize innocent unless proven guilty in a court. He has not been proven guilty in a court of law. He is not guilty now. So there are some things that he is afforded and rights. And we've got the rules of, for instance, the Supreme Court has held that, yes, we can hold somebody in jail pending their trial. He has not been convicted, but we're holding him in jail. That's okay. We're okay with that, Why are we? Because there's this possibility that it's not safe to have him out. It might be. If he's not the guy, if he's not the one, okay, we could be just as much threat right now at being killed by the Idaho 4 killer who was not Bryan Kohberger than we are if he gets out of jail. She has a point about speedy trial. Chris, I did not see the point about speedy trial. I saw that was probably one of the weakest arguments, specifically saying, help, our client has two competing constitutional rights, and he can't choose them both. Thus, you can't use the death penalty against him. Guess what? My example I used during this, the two competing constitutional rights, the right to remain silent and the right to testify in your own defense. Guess what? You cannot use them both. You have to choose. Why did my camera just change? Did I do something? Did I bump something? I don't know. You have to choose between those two. And you might say, okay, I've got to tell my story. It's the only way I can tell it. They won't let me bring in evidence any other way. I have to get up on the stand. You get up on the stand and the prosecution rips you apart and destroys you and just makes you look terrible and like the worst person on earth. And you're like, that's not fair because I had to tell my story. That was your choice. You have two rights. You should have chosen to remain silent. Here he chose to waive speedy trial so that he could have time for his defense, to prepare the defense he wanted, which is an adequate defense. Would love to have VK to get on the stand. Whew. I'm not sure if we can get closer to 0% a possibility here. I don't see that happening. Keeps flickering between lighter and darker. I know why. Because I'm using two different computers to control it. So they have different settings. Sorry, excuse me. Try a little zoom. Oh, that's a little too much. Oh, whoa, stop zooming. Zoom less or more. That's too far out. Now you get to see lights. Apparently there's no happy medium on this camera. We'll leave it like that. But now my focus is off. Focus. Focus right here is what I want. Focus on that. Okay. The happy medium is the one who gets a prediction right. It is a fancy camera, and I love it. It's tiny, too. I mean, it's about the size of a baseball. Camera pans a little too far, and it's just lab monkeys. Yes. The monkeys that are out in South Carolina, which apparently may or may not be infected with some serious disease and or toxin, are the ones that you see sitting in the hot tubs in like Siberia. They're like snow monkeys. Tim glasses I need. I fixed the shutter. Look, this down here. I fixed the shutter so that my Stream Deck wouldn't, because it looks like this normally. Watch. This is the lights. This would drive you nuts, right? First of all, it's really dark, and that's too bright. Trying to find the one that just doesn't catch them flashing quite as much. I think 1/50th on the shutter is good. Is good. Who turned out the lights? That was me. Tech makes me happy. It really does. Hot tub monkeys on the loose. That's it. All right, we've got a little bit of break. I need a little bit of a lunch break because I have not eaten and I'm starting to shake just a tiny bit. Can your microphone change your voice? It does. It does change my voice somewhat. For instance, I can sound terrible. I can sound like this, and this. I know you might say it sounds the same, but this sounds a lot different. So it doesn't do like voice changes to make me an alien or something like that. But. What's the fix for that? Let's take a step back from the death penalty in people and now talk about monkeys. What's the fix if these monkeys establish a little colony in South Carolina? Mr. Torso says, honestly, I think all the casing, the joint evidence of Kohberger around the house multiple times in the months before, late at night, is going to sink him more than the crime scene forensics evidence. I think the forensics is going to be the cherry on top. No, but I can record you and play you back. Need an EDB voice changer. Does she have one? I might have to ask her which one she has. All right. We have approximately half an hour before we come back from court. Court says it's going to resume shortly. We're going to be 4 boxes till then. Let's see. Make this full. What is left on the agenda is lack of grand jury, international law, standards of decency, and trifurcate. So we have those 5 issues, 4 issues left to argue. And we have a new attorney who just walked in the door. He's late, but he's here now, and he's going to be addressing that. I think we also do get the... See, did the state address Speedy trial already? Bring in a natural predator. I did like that movie. Don't be like Australia. Don't introduce anything into the ecosystem to get rid of the monkeys. Yes, because then you just have a larger problem. That's ask Australia about rabbits. They're terrible. Guess they've got, like, kangaroos are pretty crazy as well. And goats. And feral pigs. Want to box a kangaroo. Ivan, you only want to box a kangaroo because you've never seen it happen. The kangaroo, actually, what they do is they bear hug you, and they lean back on their tail, and they tear out your insides with their hind feet. It's not a boxing match like you think. They're vicious. All right, on that note, I'm ready for lunch. Cane toads. We'll be here. Okay, we have the podcast already built, but we're going to be back with Bryan Kohberger for the last, I don't know, about an hour, maybe hour and a half this afternoon as the judge comes back from lunch. And I'll make a new live stream for that one. We might even portal you over to it. Let's see. I'm not going to portal you. I'm not going to have time to do that. So I'll just say, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about half an hour. We'll be live as soon as court resumes. We'll be back just a few moments before, which means top of the hour, so about 40 minutes we'll be back. So grab a bite to eat, come back in, settle in. The judge might make a couple more rulings, but it sounds like most of these are going to be decided by a written ruling at a later date. So we'll go with that. Oh wow, don't like the flashing light? Yeah. It's only visible on camera. Like in person, they look like they're just solid lit. But that's how LEDs work. All right, we'll see you guys after break. Have a good one.